Good morning, everyone. I think we have our judges here, and so I just want to go ahead and get you all checked in. Can everyone hear me okay?
I can hear you.
Okay, fantastic. We've got, and like I said, it looks like we have all of our judges, Mark Jones, London, England, Chris Arnell, and Mason Jones. Hey, everyone, how are y'all?
Morning.
Morning.
Okay, well, we've still got a few more minutes before the round gets started, and since I have the judges, you're all good to go. You won't need to have your cameras on or your mics on during the round, so you're all good to shut your cameras off. If anyone needs anything, though, and I'm going to give my number to the competitors as well, but if anyone needs anything throughout the trial, or if you have any technical issues or anything like that, go ahead and give me a call, and I can alert IT about any issues that we have. But my number is 830 496 1495. And like I said, I'll give that to everyone again when the competitors get here. And it looks like they are popping in now. So give me 1 second.
You want to put that in the chat as well?
Yeah, I'll put that in the chat too.
Hey, Marcus.
Hey, EJ, how's it going?
Good. I just want to say hi before we started.
I like the haircut.
Thanks, man.
Yeah, no problem. Hello, Miss Nickel.
Good morning.
Good morning. Can you hear me okay?
Yes, I can. Can you hear me okay as well?
I can.
Great. Let me get myself renamed here. And then is it okay if I work with my co-chair to do a couple of technology checks?
Sure, absolutely.
Great. Thank you.
And Mr. Banks?
Yes, sir.
All right, got you checked in as well. And Ms. Nickel, I have your co-counsel, but Mr. Banks, I do not have yours here yet.
He's logging on right now, Your Honor.
Okay, no problem.
Okay, Mr. Minecoth, let's go ahead. Oh, is that the wrong camera up? Hold on. There we go. Okay. Mr. Minecoth, I'm going to adjust this a little bit up, but then are we good?
Yes, that looks good. Your chair is a little bit visible in the back there.
Oh yeah, I'll get that moved. Perfect. Thank you.
And while everyone's doing their technology checks, competitors, I just wanted y'all to know I've put my phone number, my cell phone number in the chat. In case you have any issues, give me a call and I'll get IT in here as quick as possible.
Thank you so much.
No problem. All right, y'all can continue doing your technology checks. I'm gonna go off cam and mute myself, but we'll get started here in about 5 minutes. All right. Are there any other issues, technology or otherwise, that we need to take care of before we get started?
Not on plaintiff's end, Your Honor.
Nothing from the defense either, Your Honor. We're ready to proceed.
All right. One moment. Let me make sure I get the all good. All right. We are good to get started then. Before we jump into openings, are there any preliminary matters that the parties would like to take up?
Yes, good morning, Your Honor. My name is John Banks, and I, along with my co-counsel, Mr. Riley Davis, represent Jordan Gilmore in today's case. We have a few housekeeping matters as well as a motion in limine whenever the court is ready.
Okay, let's get introductions from the defense first, and then we'll proceed into housekeeping before motions.
Yes, good morning, Your Honor. Rebecca Nickel on behalf of the defendant Chimes Department Store, along with my co-chair, Philip Meinkoff.
All right, good morning. All right, plaintiff, you may proceed with your housekeeping matters.
Yes, Your Honor. May we assume all witnesses have been pre-sworn?
You may.
Your Honor, in this case, both live witnesses are parties. Therefore, the rule does not apply and no witnesses may be sequestered under the rule.
All right.
When handling evidentiary arguments, may we assume we are outside the presence of the jury?
In this format, you may, yes.
May we also assume, once Your Honor has made a ruling, that we are back inside the presence of the jury?
Yes, you may.
In the case a witness is having difficulty accessing their electronic case file, may we share our screen constructively outside the presence of the jury for the purpose of laying foundation for that piece of evidence?
I want to make sure I understand. You say constructively outside of the presence of the jury. You want to physically share your screen, but constructively the jury can't see it. Is that correct?
Yes, Your Honor.
Okay, sure.
And just to put the court on notice, this is a bifurcated trial, and this portion of today's trial only deals with liability.
Okay.
But as a part of our negligence claim, we still have to establish a prima facie showing of injury in today's case.
Right.
We also discussed a few matters during meet and confer with opposing counsel. We've come to agreement on the pre-admission of certain pieces of evidence, and plaintiff moves to admit those pieces at this time.
Okay. What evidence is that?
It's exhibits 3, 4, 5, 6, 11, 12, 17, and 19.
Okay, and just to confirm, defense, you don't have any objection to any of those exhibits?
Yes, Your Honor, that is, or no, Your Honor, I do not have any objections. Yes, that list is correct as to our agreement.
Okay, exhibits 3, 4, 5, 6, 11, 12, 17, and 19 are pre-admitted.
Yes, Your Honor. There's deposition testimony meeting the requirements under 804 for an unavailable witness that will be read in the course of today's trial. We'll discuss the portions that will be read aloud with opposing counsel, and the plaintiff will seek to read the remainder of the deposition inconstructively.
Okay.
Your Honor, just briefly, we do have an objection to the remainder being read in constructively, as that would not allow us the opportunity to object to potential portions of these depositions that either lack foundation to be stated, don't meet within the are not within the expert's expertise, depending on the witness. So we would ask that any parts of the deposition that are being entered into the record be read. That way we have the opportunity to contemporaneously object to any material that should not be admissible in this case.
That's fair. We won't have any of the deposition read constructively, but if there is anything that you'd like to bring up, feel free to raise that at that time, as well as any corresponding objections. And while I've got you stopped for a minute, does everybody have the ability to share screen right now?
Yes, we tested ours, so we're good to go.
Great.
Yes, Your Honor.
All right. Are there any other housekeeping matters?
Along with that, Your Honor, there are also statutes that are cited as a part of the deposition testimonies. For the sake of time and judicial efficiency, may we constructively read those into the record under Rule 705 of the Federal Rules of Evidence.
You mean to constructively read the text
Statutes.
or the substance of the statutes? Yes. Identify the statutes on the record, but constructively the substance of those statutes can be read constructively.
Yes, Your Honor. That's all for plaintiff's housekeeping.
All right. Defense, do you have any housekeeping matters?
No, Your Honor, that is all the housekeeping matters we have as well, and we are ready to proceed to substantive motions.
Okay. Plaintiff, you may proceed with your motions.
Your Honor, plaintiff moves to exclude Exhibit 37 as irrelevant under 401. During meet and confer with opposing counsel, we have stipulated that piece of evidence will not be entered into, and we just want to put the court on notice of the parties' agreement.
All right. Is that fair, defense?
That is correct. We will not be admitting Exhibit 37.
Okay. Anything else?
Not from the plaintiff, Your Honor. We're ready to proceed with opening statements.
All right, defense motions.
Yes, Your Honor. And to provide some context, this is a premises liability case in which a Mr. Gilmore slipped and fell while out back of Chimes Department Store's premises. And ultimately, this case comes down to whether Chimes Department Store had control over that premises. So today, Your Honor, the defense has two motions in limine. Now, as to the first, we seek to exclude any email exchanges between a Mr. Perry Hayden, a witness in today's case, and his supervisor, as well as any testimony in his deposition regarding job performance, specifically that there was a potential issue with his performance. And we bring this motion pursuant to 801, 802, 403, and 404. Now, it's our understanding, Your Honor, based on conferring with Mr. Banks, that he does not intend to admit Exhibit 38 and 39. However, they do intend to read portions of the deposition that have to do with Mr. Hayden's performance. And the first issue with this, Your Honor, is these performance issues are based on hearsay statements from Mr. Hayden's supervisor, who will not be here to testify today. So those statements are inadmissible hearsay that do not fall under an exception. But next, Your Honor, these job performance quote unquote issues were never resulted in any discipline on the end of his supervisor or anybody else at OSHA where he worked. So these would be misleading statements to the jury under 403 and would imply that there were actually performance issues when we can't confirm or deny that there were. For all we know, this was a misunderstanding. And finally, Your Honor, the only relevant purpose this would be entered for is inadmissible character evidence under 404. The implication would be because there were performance issues in the past, Mr. Hayden did not do his job well in this instance. So we would ask that that be excluded under those rules.
Response?
Yes, Your Honor. These email exchanges go to the credibility of this witness as an expert in this case, Your Honor. As such, they're always relevant in the jury's weighing of this expert's opinion. Further, Your Honor, based on the witness's deposition, these emails were relied upon in the deposition testimony, and as such should at least be read to the jury under Rule 705 along with the statutes.
So you're saying that they were relied upon by this particular witness in making his conclusions? Is that what you're saying, Mr. Banks?
No, Your Honor. We're stating that they were stated in the deposition and were not relied upon, but attack the credibility of this witness and his ability to do or not to do his job properly.
Response?
Your Honor, if I may clarify. Yeah. So first, Your Honor, there's not a foundation for this witness, this deposition witness, to be entered as an expert. So 705 would not be applicable on this basis. And these statements certainly about his job performance were not what he relied upon in coming to his conclusions in this case. Further, Your Honor, in order for credibility to be a valid argument here, we'd need to be able to confirm that these job performance issues were in fact issues. That's our entire problem with this evidence, is that there's no ability to confirm or deny here that these job performance issues actually have to do with his credibility. In fact, it's more likely that they were simply a misunderstanding, and we have no ability to confirm or deny that. So this would be incredibly misleading under 403 for it to be allowed to be used to attack credibility in this case.
Okay. I will deny a motion to exclude, but I will grant your motion in limine, and we'll talk about it before that evidence is brought up before the jury.
Understood, Your Honor.
Anything further?
Yes, Your Honor, we have one additional motion, and that is to exclude Exhibits 10 and 14. Now, Exhibits 10 and 14 are two incident reports drafted by Chimes department store managers. Now, we seek to exclude these pursuant to 805, as these documents are not only hearsay, they are hearsay within hearsay. We have the first level, Your Honor, which is the drafting of the incident report by the manager of Chimes, two different managers in this case, but both employees at the time. And while that level might fall under an opposing party statement, there is an additional level to these reports, which is the statements made by the employees that were involved in the accidents. And those statements were not made within the scope of their employment. In fact, they were against the interest of the company and certainly not made within the scope of their job at Chimes. So that second layer of hearsay would be inadmissible in this case and not fall under an exception.
Response?
As to the second layer of hearsay at issue here, Your Honor, these statements were made by employees acting within the scope of their employment and were not against the interest of the defendant corporation. In fact, based on the defendant corporate corporation representative, these statements were required under the defendant's own procedures to report any instances that happen on company premises. And these statements were made pursuant to that duty.
Your Honor, if I may respond.
You may.
Just because the rules state that they should make an incident report in these cases, Your Honor, doesn't mean that the statements were made within the scope of their employment. A cashier making a statement about a fall is not a statement made within the scope of their employment as a cashier. That statement is specifically made outside the scope of their employment and outside of that position.
Okay, I will grant a motion in limine. Again, I'm not going to exclude, but we can talk about it before it's brought up before the jury.
And just to clarify, Your Honor, so we should basically have a constructive sidebar before discussing either of the issues in these motions today?
Exactly.
Great. Thank you, Your Honor.
All right, anything further?
Not from the defense, Your Honor.
Your Honor, at this time, we'd like to put the court on notice of a pretrial order, specifically 7C, that states the court will not entertain any objection that any witness who may qualify as an expert was not properly designated under Federal Rule of Procedure 26. Just because opposing counsel fails to admit this OSHA employee as an expert does not mean that I on cross would be able to do this, would not be able to admit this witness as an expert and falls under that pretrial order under 7C.
Your Honor, if I may.
You may.
That stipulation would go to the fact that they weren't properly tendered. The problem in this case is Mr. Hayden has no foundation to be an expert. He does not have any qualifications or anything of that nature. He would not be an expert witness in today's case.
My understanding is that the designation goes, or excuse me, that the pretrial order goes to the specific designation under Rule 26 as well. And so that motion is denied. But again, if there's an objection to the foundation that's laid, feel free to raise those objections at the appropriate time. All right, are we ready to proceed with openings?
Yes, Your Honor.
All right,
Yes,
plaintiff,
Your
you may proceed.
May it please the court. Some people want all the control and none of the responsibility. This defendant wanted all the control over the landing behind their store, but none of the responsibility that comes with their neglect. The defendant, Chimes Department Store, operates a department store which sells everything from clothes to tools in their store down on Bosque Avenue. Chimes has been around for decades. It was founded by the current owner, Reese Geller's grandparents, who then passed it on down to Mr. Geller's parents, passed it down to Mr. Geller. And in 2005, the store was doing well. So well that the defendant outgrew its location at that time and needed to find a bigger space. That's when they found the space they currently occupy and have been in for the last 15 years. But when the defendant moved to their current location, they decided to make some changes, some structural changes to make sure it was more suitable for their use. So in January of 2005, Mr. Geller requested that the owners of the property, Kermit Realty Group, remove the railing from the steps and landing area behind the defendant's store so they could use it as a loading dock. Not only did the defendant request that Kermit make these changes, but they also agreed to pay for the costs associated with making those changes. The defendant wanted all the control over the landing area, and they got it. This is how the landing appeared after the defendant took control and removed the railings. No railings around the landing, no railings around the stairs. Here, you can see where the railings were. The holes at the top and the bottom of the stairs were the poles for the rails were supposed to be. You will learn that when the defendant took control of the landing, they also accepted the responsibility for anyone getting hurt on that same landing. And on January 23rd of 2019, someone did get hurt. That someone was Jordan Gilmore. I'd like you to meet Jordan. Jordan, could you turn on your camera for us? Mr. Gilmore is from right here in Waco. He was a cashier at Chimes Department Store for about 10 years, spending most of his time in the front of the store helping check people out, ringing up their purchases, and taking out the trash from time to time out back. Thank you, Jordan. You can turn the camera off. And even though Mr. Gilmore has quit smoking now, when he worked for the defendant, he was still a smoker. And on January 23rd of 2019, during one of his smoke breaks, Mr. Gilmore fell from the defendant's landing and tore up his knee. Being the middle of January, it was cold that night. Mr. Gilmore and another employee, Riley Huntsberger, went out to the landing to smoke because that's where the defendant required their employees to smoke. It was around 7 p.m., which was about 2 hours after sunset in January. The back of the store was dark, pitch black, and the only light fixture was not turned on. And even though the employees had complained about the light not being turned on at night, they were simply told that the defendant did not have access to the switch. So employees, just like Mr. Gilmore, were forced to go outside in the dark to smoke. With no outside light, Ms. Huntsberger stood on that landing, holding the door open while she smoked and hoped some of that light would shine out onto the landing. And afraid that the smoke from his cigarette would drift back inside, Mr. Gilmore climbed down the stairs to smoke. On his way down, with no railing to use for support, Mr. Gilmore braced himself against the wall of the store to make sure he got down those stairs. And after finishing his smoke, Mr. Gilmore began going back to the top of that landing. But the door of the store into the stairs was open. As you can see in this picture, the door extends all the way over that second step down from the landing. But that night, Ms. Huntsberger wasn't holding the door all the way open like it is in this picture. Instead, the door was only partially open and blocking more into the middle of the stairs. As Mr. Gilmore made his way back up the stairs, he had to move further from the wall, closer to the edge with no railing to protect him. And right when he got to the top, right when he put his right foot onto the top of that landing, something happened. His foot started to slip, and Mr. Gilmore felt himself starting to fall. And trying to steady himself, but realizing there was nothing else he could do, Mr. Gilmore jumped to avoid falling face first. Instead, landing on his feet, jarring his knee and falling backwards onto the ground. And not long after, Mr. Gilmore was forced to have total knee replacement on the knee injured in this fall. We have brought this case against the defendant for negligence and will prove to you that the defendant was negligent, that the defendant failed to use ordinary care to protect Jordan Gilmore by showing you three things. One, that the defendant knew the landing posed an unreasonable risk of harm. Two, that the defendant failed to make the landing safe. And three, the defendant exercised control over the landing and surrounding area. To explain to you how the landing posed an unreasonable risk of harm, we will call Kelly Daines to the stand. Ms. Daines received her Bachelor's of Science in Mechanical Engineering from the University of Wisconsin before later becoming a professional engineer in 7 states, including ours. And during her career, Ms. Daines has investigated over 60 incidents just like this one. Ms. Daines will tell you that based on the International Building Code and regulations from the Occupational Safety and Health Administration, known as OSHA, that the defendant failed to keep the landing area up to code and properly maintained, which created an unreasonable risk of harm to the defendant's employees. Second, we will show you that the defendant failed to make the landing area safe. Not only did the defendant fail to meet the IBC and OSHA guardrail codes, but the defendant also failed to make sure there was adequate lighting in the landing area. Finally, we will show you that the defendant had control over the landing area. The law of our state provides that a tenant is responsible for areas it leases and those areas adjacent to the space they lease and actually control. And control can be proven by an actual exercise of control. You will learn that the defendant exercised control over the landing area by directing the removal of the guardrails, directing the concrete drive up to the landing be poured, and by paying for the charges and directing their employees to work, even smoke, in that landing area. Some people want all the control, but none of the responsibility. This defendant wanted and took all the control over that landing behind their store, but wants to take none of the responsibility that comes with their neglect. Make the defendant take responsibility. Find for Jordan Gilmore.
Thank you, plaintiff. Defense, are you ready to proceed with your opening?
Yes, Your Honor.
All right, you may proceed.
Thank you. Make sure all my technology is set up here. There we go. On January 23rd, 2019, Mr. Gilmore did tragically slip and fall outside behind the premises of Chimes department store. You see, me and Mr. Banks agree about that. But he left out one important fact. And that is that Chimes department store did not have control of that area out behind their premises. No, Kermit Realty LLC, the property owners, had control of that area. You see, members of the jury, this case is about the failures of a corporation, but not the defendant corporation Chimes department store. You see, it's about the failures of Kermit Realty LLC, because Kermit was in control. Members of the jury, Kermit Realty signed a lease agreement with Chimes department store in which they made a promise. They said, in return for rent, we agree to keep the portions of your property that are common areas that are in our control. We agree to keep those safe. We agree to maintain them. That was the promise that Kermit made when they signed the lease with Chimes department store. Now, Chimes held up their end of the bargain. They paid on time. Kermit Realty, well, they didn't hold up their end of the bargain. That is what today's case is about. It is about who had control of that area where Mr. Gilmore fell. But fundamentally, members of the jury, it's about fairness. Because today's case is what's called a premises liability case. And in these types of cases, we've decided as a society that property owners and people who have control over areas of land or areas in general, well, they have a duty to make sure that when people are on that property or in that area, they are kept safe. That is the basis for a premises liability action. But today, contrary to what Mr. Banks said, Chimes department store couldn't have kept that area safe. It's not just that they didn't, members of the jury, it's that they were not allowed or permitted to make the changes necessary that Mr. Banks is going to argue would have made that area safe. That is why it was not in their control. And this is the preliminary question that you as the jury have to decide today. Before you can even get to those elements of negligence that Mr. Banks mentioned, you have to determine who had control. Now, this issue can get very complicated. There's a long lease involved in today's case and some legal terms. And while we will show you that based on the lease and the law, that Chimes department store did not have control and that Kermit Realty did, we ask you to pay closer attention to the actions of the parties. And ask yourself, based on the actions of the parties, who was in control? Now, I want to be very clear. Members of the jury, use is not control. Use of a space is not control of that space. You see, I'm using an area in our locker. I have my laptop set up. I've put my water bottle out. I am using this space, but I am positive my administration would agree that I certainly don't have control of this space. I certainly couldn't take down the door. That would be pushing it too far. Why? Because use is not control. So while Mr. Banks has mentioned a variety of ways in which Chimes department store used that space, pay attention to who exercised control. He mentioned that Chimes department store had that railing removed. Well, I want you to listen closely to the evidence today because, well, that story, it's not as simple as he made it seem. Use is not control. And Kermit was in control. So let me introduce you to the men and women of Chimes Department Store. You see, Chimes Department Store is a small family-owned business. They've been a part of the community for many years. They take great pride in ensuring that they provide good quality of service to their customers and in ensuring that in the space that is in their control, they create a safe environment for their customers and their employees. But you see, Chimes Department Store understands the basis of premises liability, and that is that when an area is not in your control, not only is it not your job to keep it safe, you aren't allowed to take the steps necessary to keep it safe. That is why Chimes Department Store is the wrong defendant in today's case. This is about the failures of a corporation, but it's not about the failures of Chimes Department Store. Members of the jury, the case doesn't end there though, because we will show you today that not only was Chimes not capable of making the changes necessary to have made that area safe for Mr. Gilmore, Kermit Realty was and was negligent. Those three elements that Mr. Banks just mentioned, yes, Kermit is the party that we will show you meets all three of those elements. Specifically, Kermit knew or reasonably should have known that those stairs posed an unreasonable risk. Kermit Realty created an unreasonably hazardous condition, and Kermit Realty failed to exercise ordinary care in taking the steps necessary to make that area safe. Members of the jury, let's talk about this, because there's a lot of elements in today's case that could have contributed to Mr. Gilmore's fall, and none of us were there that day except for Mr. Gilmore. So let's break down those elements. You see, there was the concrete stairs, the guardrail, and the light. But what you'll hear today is that Mr. Gilmore had been up and down those stairs over 10,000 times during his time at Chimes Department Store. These stairs, he had been up and down and up and down. He knew these stairs like the back of his hand. But there was something that was different on the day of January 23rd, 2019. The only condition that changed about these stairs over time, over the course of his 10 years there, the one thing that changed was not the location of the steps, the angle at which they were, the placing of the wall, none of that changed, but the condition of the concrete, well, that Kermit Realty had allowed to continue to disintegrate over those 10 years. So that concrete, every time Mr. Gilmore went out, posed more and more of a hazardous risk. And without a guardrail there, well, Mr. Gilmore was out of luck. So again, me and Mr. Banks agree, these stairs and that guardrail, those were unreasonably hazardous conditions. Those were conditions that should have been fixed. Those were conditions that the ordinary person exercising a reasonable degree of care would have fixed. The party who had the ability to fix that, the only party that was allowed to make those structural changes, well, that was Kermit. Because Kermit was in control. Members, the evidence will show that yes, those stairs were unreasonably hazardous, but Chimes did not have the ability to fix that. Kermit did. So I ask you to ask yourself throughout this trial, is it fair to hold someone accountable for something that they couldn't have fixed even if they wanted to? We will show you today that members of the jury, that is not fair. The men and women of Chimes Department Store shouldn't be here today. Kermit Realty should. And that's why at the end of this trial, I will come back up before you and I will review all of the evidence with you. We'll look at the provisions of your jury instructions that require you to establish control. We'll look at that lease agreement and what it says about who was legally in control. But more importantly, we will look at the actions of the parties. And remember, use is not control. Kermit was in control. And that is why at that time, we will ask you to find the only verdict that aligns with justice and fairness in today's case. And that is to find Chimes Department Store not liable. Thank you.
Thank you, defense. Plaintiff, are you ready to call your first witness?
Yes, Your Honor. Plaintiff calls Jordan Gilmore to the stand.
Hello, Mr. Gilmore, and you've been sworn.
Please introduce yourself.
Hi, my name is Jordan Gilmore.
Now, Mr. Gilmore, before we get too far into this, I'd like for us to get to know you a little bit better. How old are you?
I'm 48.
Where do you live?
I live in Waco.
How long have you lived in Waco?
I've lived here for all my life.
So, being a hometown boy, have you had any jobs here in Waco?
Yes, sir. I worked at Chimes for over 10 years.
Now, when you weren't working at Chime, what'd you do?
I went to church.
Objection, Your Honor, relevance.
Response?
Your Honor, I'm merely introducing the plaintiff to the jury so they know who the parties are in this case.
I'll allow the plaintiff to go into some background on the witness. Overruled.
I'll ask you again, Mr. Gilmore. When you weren't at Chime, what'd you do?
I'm a frequent at my local church, 7th and James Baptist. I used to go every Sunday for Sunday school. Besides that, I was part of the book club and I just played cards.
Now I'd like to talk with you more about your 10 years at Chime. What did your job as a cashier require you to do?
I was a cashier on the front, helped around in the department store, and then I also took the trash out quite frequently.
Where did you take the trash out?
I would go to the back, I think about 2 times a day. I would take trash from the front throughout the store to the back dumpsters.
Now, where was that back dumpster located?
It was literally at the rear of the department store. So there would be a front where customers would enter, and then all of the trash was towards the other end. So the customers wouldn't see where we take the trash.
Was there any platform or anything back there by that dumpster?
There was a platform when you came off with stairs to go down. So we would go out, we would open the door, go on the platform and go down the stairs to throw the trash out.
Now, besides taking the trash out, those back doors near that platform, were you asked to do anything else out there?
Not necessarily, but I did go out there to smoke.
Why would you go out there to smoke?
We were told to by our managers that we could only smoke in the rear of the store outside.
Were you told you weren't able to smoke anywhere?
We weren't able to smoke anywhere else except for behind the store outside.
Mr. Gilmore, I want to shift gears here and talk more about what happened on the night of January 23rd of 2019. What do you remember about that night?
That was a kind of a long shift. I started at 12 and I worked all the way until closing. I believe that was 8. About 7 o'clock, I went to the rear of the store to take a small smoke break. I went with one of my friends who was also an employee, Riley, and we both went outside at the same time.
Did anything happen out there that night while you were on a smoke break?
Yes. It was late out. It was probably 5:30 or 6. So it was in the winter time. So it also, the sun set earlier. It was pitch black outside. So the only light that was really coming towards the rear of the store was from the door when it was opened. So I went down the stairs, but since it was really dark, I did hold on to the wall, and I smoked a little bit, and then came back up slowly through while I was holding the wall as well, and then I fell.
Now, going back just a little bit, you mentioned that the light from the door was leaking out. Was there not a light outside?
No, there was not any light in the back of the store outside.
Was there a light fixture or anything back there?
I believe there was a light fixture, but it wasn't working at all.
Why not?
As far as we know, there is a light fixture, but the switch isn't in Chimes's control or something, or usage. So they never fixed it or put it on or anything. They always just blame someone else.
When you say they, who do you mean?
Our manager always told us that the switch was with, I guess, like a neighbor, Tractor Supply.
Now,
They
you
never
mentioned-
actually moved it.
okay. You mentioned you went down the stairs. Why did you go down the stairs to take your smoke break?
It was windy outside. So when I was smoking, I didn't want the smoke to go inside the department store, and then I get in trouble.
Okay, so you take your smoke break and you start coming up the stairs. What happens?
Right. So I came up the stairs, and while I was doing that, Riley was still holding the door open. And I had to go kind of like around the door to get inside by the way I guess the door opens towards the stairs. And when I tried to step up onto the landing, my foot slipped and I just fell off the landing. And I really tried to land on both of my feet, but the ground where I fell was like uneven. So I landed with the majority of my weight on my right leg, and then I ultimately fell backwards onto my butt.
Now, I want to back up just a little bit again. You said the door was still open. Would you recognize a picture of that door?
Yes, I would.
Citing court and opposing counsel to was already been admitted into evidence as exhibits 3 and 4. Permission to publish.
You may.
Mr. Gilmore, we're looking here at exhibit 3, which is a picture of that door open near those stairs on the landing dock. Is exhibit 3 a fair and accurate representation of what you saw on January 23rd of 2019?
Yes, it is. It was night out, but yes, that is the door.
So just describe what we're looking at in terms of where the door is in relation to that landing platform.
Okay, so essentially this is kind of the end of the actual landing platform. You can see the stairs going down. So when you would come out of the actual department store and you look to the right-hand side, those are the stairs that would take you down onto the actual, I guess the actual parking area. So in order to go down, you have to actually shut that door and then go down.
Now, turning your attention to exhibit 4. Is this another picture of the same type of condition you were just talking about?
Yes, it is.
Now, what did you do when you felt yourself starting to fall as you move around that door?
Well, when I felt myself fall, I really tried to kind of land on both of my feet and I guess like stay standing up. But because of the way that platform was kind of designed, I couldn't do that. So I fell on my butt.
What happened after you fell?
After I fell, Riley, who was with me at that time, checked on me, and my right leg and my hip hurt. But otherwise, I thought it was okay at that time. So I kind of slowly got back up and walked up the steps, and I was in a lot of pain. But I walked up, and the door was open, and we both just went inside.
What happened once you went back inside the store?
I told the manager on duty, Lane Kim, what had happened, and she had mentioned that they were meaning to fix those stairs a long time ago, or they should have, but never got to it because the owners had other things to work on.
Now, a minute ago, you said you felt pain in your leg and your hip. Were you injured?
I was. At that time, I didn't think I was. So I finished the shift and I went home. I took some Tylenol that night and then tried to sleep it off. But then the day after, I was in extreme unbearable pain. So I went to the ER and saw an orthopedic surgeon specialist.
Did you end up having any surgery from that surgery?
Yes, I needed a full knee replacement.
Pass the witness, Your Honor.
Whenever the court is ready.
Yes, defense, you may proceed.
Thank you. Good morning, Mr. Gilmore.
Good morning.
Now, I want to start by talking about some things you don't have knowledge of here today. You were not in management at Chimes.
No, I was not.
You were a cashier.
Correct.
So you didn't have knowledge as to the lease agreements between Chimes and whoever owned the property?
No.
And you can't testify as to what would be in those agreements.
No.
And on direct, you stated that Lane Kim, the manager at the time, had told you that the reason they hadn't fixed the stairs is, quote, the owners had other things to work on, right?
Correct.
You can't testify as to who she was referring to when she said, quote unquote, owners.
No.
Then I want to talk about what did not cause your fall. You would agree with me that you were pretty familiar with that area out back.
I was.
In fact, you have testified previously that you'd been out there about 20 times a week.
That sounds right.
And multiply that by 52 weeks in a year, that's about 1,000 times a year.
Correct.
And you'd been at Chimes for 10 years.
Correct.
So it'd be fair to say that you went out on that landing over 10,000 times.
Not really the best at math, but
Well, you'd agree with me that 1,000 times 10 is 10,000, right?
didn't finish high school, but that sounds right.
So, Mr. Gilmore, I also want to establish in all those 10,000 times, you'd agree with me that it was a regular occurrence that that light was off.
I didn't go much at night. Most of those, if that 10,000 number is right, were in the day. So I don't really know much about the lighting at night.
Well, I want to be clear because I'm just using your words here. It was a regular occurrence that that light was off at night.
Right. But no, I didn't know about like 10,000 times if it was off. I don't know about that.
Right. Just that it was a regular occurrence within that 10,000 times that it was off.
Right.
So it'd be fair to say that it was a regular occurrence for you to go out to that landing in the dark with that light off.
Right.
Then I want to talk about what might have caused your fall then on that day. Now, in your own words, as you reached the landing, you stepped up and put your foot on the top landing.
Right.
And then something happened and your foot slipped.
Right.
And you don't remember exactly what happened that caused you to slip,
Correct.
but you do remember putting your foot on that top landing.
Correct.
I want to go ahead then, and Your Honor, can we have permission for my co-counsel to publish what's been previously admitted as Exhibit 5?
May.
Thank you. So, Mr. Gilmore, this is a diagram of that area where you slipped that day, right?
Right.
And as you testified in direct with those pictures, at the time you fell, the door was open at a 90-degree angle, like it is in this photo, or this
Correct.
demonstration. Thank you. And as you walked up those stairs, then you had to step on that corner. I'm going to have Mr. Minecoth go ahead and put up a red circle. You'd agree with me, you had to step right about there to get around that door and go inside.
Right.
Your Honor, permission for my co-counsel to publish what's previously been admitted as Exhibit 6 and 17 side by side.
You may. And you are you all are free to freely publish any exhibits that have been pre-admitted.
Great, thank you, Your Honor.
No problem.
So, Mr. Gilmore, you'd agree with me that looking at these top pictures, there's a chunk of concrete missing on that top right-hand corner of that step.
Right. Yeah, right. I think I'm talking about like that exact corner.
Yes.
Yes, there
the
is.
top one. And that's exactly where you had to step that night when you fell.
Not exactly. There was probably a couple more, inches there, but yeah, on the most part.
But my point is, Mr. Gilmore, you had to step near the edge of that concrete where that chunk was missing.
Right. Again, there was still other room there, but I could see how somebody could step on there.
Well, Mr. Gilmore, I'm not asking if somebody can step on there. My question was much simpler. You had to step around that door in the area of that missing chunk of concrete in order to get in that night. Yes?
Right.
No further questions, Your Honor. We can take that down, Mr. Michael. Thank you.
Any redirect?
No, Your Honor. May the witness be excused.
You may. And plaintiff, you may call your next witness.
Your Honor, at this time, plaintiff calls Kelly Danes by deposition. May I read the questions of the portions of the deposition we are offering, and may Mr. Davis read the answer to those questions?
Absolutely.
Would Your Honor like for me to instruct the jury as to what a deposition is, or would Your Honor instruct the jury, or would you prefer we constructively instruct the jury?
We'll instruct the jury constructively.
Yes, Your Honor. One moment when my co-counsel sets up.
Sure.
One moment, Your Honor, my co-counsel was kicked off the Wi-Fi.
Do we need IT?
No, Your Honor. It's something on our end.
We also can share co-chairs if we need to, too. Oh, perfect. He's there. Okay.
Sorry about that, y'all.
Citing court and opposing counsel to page 8, line 16 through page 9 at line 3. Okay, what opinions have you come to in this case?
First, the International Building Code and the regulations from the Occupational Safety and Health Administration apply to the stairs and landing in question, and the facilities in question must be in compliance with those codes and regulations.
What is the basis for that opinion?
Well, in regards to the International Building Code, the city of Waco adopted that code and incorporated it into its own city ordinances on March 20th, 2001. The OSHA regulations were enacted into law in 1970. So both the IBC and the OSHA regulations would apply to whoever was responsible for the maintenance and repair of the area where this incident occurred.
Citing court and counsel to page 9, line 9 through 13. All right, so which portions of the IBC codes and the OSHA regulations did you find important in this case?
First, the general duty clause in the OSHA regulations, which can be found in 29 USCS section 654, and the maintenance provision under section 3401.2 of the IBC.
Citing court and opposing counsel to page 11, lines 6 through 19. What other portions of the IBC codes and the OSHA regulations did you find important in this case?
OSHA 1910.37B1 and IBC 1006.1, which both deal with lighting.
Why are those significant?
Well, 1910.37B requires that lighting must be adequate and appropriate for a building exit like this one. And 1006.1 requires that any means of egress must be illuminated at all times the building is being occupied. In this case, there was a light above those stairs, but there was no switch for that light inside the Chimes store. So there was no way for employees to turn that light on when they went outside at night. A switch like that should have been installed long before this incident to make sure that employees could see where they were stepping.
Citing court and counsel to page 11, line 24 through page 12, line 14. What's next?
Next, we move to OSHA 1910.23D1 and 1910.24H and IBC 1009.11.
Why are those significant?
All of these provisions require that stairways or flights of stairs must have guardrails or railings on any exposed side. Here, there was no guardrail on these stairs on the exposed side, which is obviously dangerous.
Do you know if there was ever a guardrail on those stairs?
Yes, there was, and it was removed at some point.
How do you know that?
Well, first, you can just look at the photographs and see where the guardrail used to be on those stairs. You can see the broken off piping in the concrete. But second, there is a photograph showing a guardrail on those stairs and that landing.
Citing court and counsel to page 14, line 22 through page 15 at line 15. Anything else?
IBC 1005.2 states that doors opening into the path of egress travel shall not reduce the required width to less than 1/2 during the course of the swing, and that when fully open, the doors shall not project more than 7 inches into the required width. When the door is open like it was at the time of this incident, it obstructs the path up or down the stairs to a 1-foot space between the edge of the door and the edge of the platform or the stairs where the plaintiff fell.
Any final thoughts?
Honestly, I just don't know what the
Objection, Your Honor, if I may elaborate on what's about to be said.
You may.
Yes, Your Honor. So the next portion of this statement is one in which this witness states that if a certain set of things would not have happened, the plaintiff's or would have been fixed or would have been differently, quote, the plaintiff's fall would not have happened. This individual is by no means an expert in fall reconstruction or anything of that nature, and therefore it would be speculation. This individual witness is an expert in regulations, and therefore the scope of her testimony and the scope of her opinions needs to remain within that.
Response?
Yes, Your Honor. This witness is a professional engineer, has taken various continuing education initiatives regarding to the proper building and structure of certain guardrails, lighting fixtures, and doors. As a part of those regulations, there are weight and load requirements. As such, this expert is able to testify based on everything she knows on whether or not a railing would have been able to support a fall based on the force they are required to take per OSHA and IBC regulations.
Your Honor, if I may.
You may.
The problem is there's a variety of factors here. As this next part of this witness's testimony states, she's discussing the lighting, the landing, the patch of concrete, the guardrail, and she says if all of that would have been fixed, the plaintiff's fall would not have happened. This is not her stating that the guardrail couldn't support his weight or could have supported his weight. This is much broader than that and outside of her expertise and would be speculation.
Anything further from the plaintiff?
Yes, Your Honor. This witness has extensive knowledge on OSHA, and OSHA's guidelines and regulations are meant to keep employees safe at employer work sites. The reasoning and logic behind those guidelines are exactly what opposing counsel is citing to and would be within this expert's knowledge with an extensive knowledge of OSHA and IBC regulations that speak to explicit actions that can prevent potential injury.
Objection overruled.
Any final thoughts?
Honestly, I just don't know what the defendant was doing here. All of this could have easily been fixed by putting up a guardrail around those stairs and landing and patching the cracked concrete on those steps. It would have been easy. And if the defendant had taken these simple steps, putting a guardrail along those stairs, putting a guardrail around that landing, making sure it was well lit, patching the concrete, then the plaintiff's fall would not have happened.
No further portions will be read aloud, Your Honor. At this time, we seek to constructively read in the statutes referenced by this expert in the read out portions of the deposition.
All right, you may do so constructively.
Would Your Honor prefer me to cite specifically to which portions?
You can cite the statutes for the record, but you need not go into the substance of the actual text.
Yes, Your Honor. 29 USCS section 654, IBC sections 3401.2, 1006.1, 1009.11, 1012.1, 1006.2, 1005.2. OSHA regs 1910.32B1, 1910.23D1, and 1910.24H. Pass the witness, Your Honor.
Defense?
Yes, Your Honor, I'll give my co-counsel a moment to, there he is.
Certainly.
Right. Turning counsel and court's attention to page 3, line 22. Based on what you do for a living, is it fair to assume that you regularly testify in lawsuits?
Yes, no question about it. I testify and work as an expert on cases on a regular basis. To be honest, preparing expert opinions in lawsuits like this one, testifying in depositions, and testifying at trials are about 99% of what I do at this point.
Moving down to page 4, line 21. How did you get involved in this case?
I got a call from the firm representing the plaintiff, Jordan Gilmore. It's a firm I've done work for in the past, so this isn't the first time I've consulted in one of their cases.
Page 5, line 1. Guess that means they liked what you did in those other cases.
What can I say? I'm good at what I do.
Kelly, I'm showing you what has been marked as Exhibit 15. Do you recognize this?
Yes, it is the invoice for the work that I've done so far in this case, which obviously doesn't include my time today or my time for testifying at trial if I have to do that.
Is Exhibit 15 a true and correct copy of the invoice for your work on this case up to this point?
Yes, it is.
Your Honor, at this time, we'd move Exhibit 15 into evidence.
Objections?
No objection, Your Honor.
Exhibit 15 is admitted.
Moving to page, scroll down. Moving to page 8, line 16. Okay, what opinions have you come to in this case?
First, the International Building Code and the regulations from the Occupational Safety and Health Administration apply to the stairs and landing in question, and the facilities in question must be in compliance with those codes and regulations.
Moving to page 9, line 4. Do you know or have any opinion on who was responsible for the maintenance and repair of these steps behind the Chimes store?
No, that's not what I was asked to do. I assume it was Chimes, but that's just a guess.
Page 10, line 4. Let me ask you this. If Chimes wasn't responsible for maintaining that area where the stairs were located in the back of the store, would the IBC apply to Chimes in regards to that area?
No, it wouldn't. The IBC applies to whoever has the responsibility to maintain that area.
No further questions, Your Honor.
Any redirect from plaintiff?
No, Your Honor.
All right. Does plaintiff have any further witnesses that you wish to call?
No further witnesses, Your Honor. Plaintiff rests at this time.
Okay. Any motions?
Yes, Your Honor. I do have a Rule 50 motion, which we can either do before or after if we choose to take a break, whatever Your Honor prefers.
All right. Well, let's go ahead and take a break and then we can handle the motion at the start of the next portion. All right. Let's go ahead and have a 5-minute break. Is that good for everybody?
Yes, Your Honor.
Defense.
All right. I'll see you on 5.
Thank you, Your Honor.
Are the parties ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
All right. Before we get started, I believe the defense had a motion.
Yes, Your Honor. At this time, we bring a Rule 50 motion for a directed verdict. Even in viewing the evidence in the light most favorable to the plaintiff, there has been no showing of Chime's control of the area where this accident occurred, the preliminary question that the jury would have to determine before even assigning negligence. And since there's been no evidence of control of Chime's behalf, while there has been no evidence of control on Chime's behalf, there has been evidence that Kermit Realty had control. Specifically, Chime's department store couldn't remove that railing from that location without the approval of Kermit. And the group that actually removed the railing was Kermit Realty. So with that, Your Honor, we move for a directed verdict at this time.
Plaintiff?
Yes, Your Honor. As a matter of control, opposing counsel banks on control expressly in a contract while the law allows for actual use of control based on actions. And we have heard that this employer, the defendant, sent employees out back to take out trash, use that area as a loading dock to load and unload their merchandise, and to have smoke breaks that if they were going to smoke on premises had to go around back. Based on that alone, Your Honor, a reasonable juror, when viewing the facts in light most favorable to the plaintiff, could definitely conclude that this defendant had control of the area by exercising the right and demands for their employees to use that area exclusively.
All right. I believe based on the evidence that we've seen so far that there is a fact question. And so I will overrule that motion, or excuse me, deny that motion. We had a visitor a moment ago. Does anyone know an Owen Maddox? I don't think he's supposed to be in this room, so I'm not going to let him in, but I just want to confirm that before we get started.
He clicked the wrong link, Your Honor.
Okay, no problem. All right, defense, you may proceed. Call your first witness.
Yes, Your Honor. At this time, we call Reese Geller to the stand. May we proceed, Your Honor?
You may.
Thank you. Mr. Geller, can you please introduce yourself and spell your last name for the jury?
Hi, my name is Reese Geller, Geller.
And Mr. Geller, what is your role in today's case?
I am the owner of Chime's department store.
Well, then I want to talk about that a little bit more. How long have you worked for Chimes?
I've owned it for the last 10 years, but been working there since I was out of college.
So would it be fair to say you've been working there for your entire career?
Yes.
And what all roles have you had at the company prior to being owner?
I started in the buying department, and then I've worked my way up. I've worked pretty much everywhere.
And what does Chimes department store do or sell?
We're general and local department store, so kind of like JCPenney or Macy's, but smaller. You can buy basically anything.
Well, then with that in mind, I want to talk about some things that have come up during the trial today. We've heard a lot of mention of a guardrail. Was there a guardrail out on that back landing at the time of the accident?
No.
And was there ever a guardrail out there?
There was before we had it converted to a loading dock.
And when you say you had it converted to a loading dock, what did that process look like?
Well, we had to ask permission from Kermit Realty, the landlord. And then we had that done, taken the guardrail taken off.
And to
after
be
they
clear,
gave us permission.
I apologize, Mr. Geller, the Zoom delay. Did you yourself take out the guardrail?
I believe we did with their permission.
Well, when you asked Kermit for their approval, did they agree to take out the guardrail?
I'm sorry. Kermit removed it and from the loading dock and the landing area and the steps at our request.
So, Mr. Geller, why didn't you just remove it? Why did you ask for approval?
We had to. It wasn't an area that was in our lease.
So we'll come back to the lease in a moment, but I also want to talk about this issue of the light. To be clear, was it feasible for you to have installed a light switch?
Yeah, we could have installed a light switch.
So I also want to ask, did Kermit ever object to the removal of the railing?
I don't believe they did, no.
So then let's go ahead and turn to who had control of the area where the accident occurred. Were you involved with the creation of your lease?
Yes.
So you're familiar with the terms in it?
Yes, I'm familiar with the terms of the lease.
Then Your Honor, permission to publish what's previously been entered as Exhibit 11.
You may.
Mr. Meinkoff, let's put that up. Great. And I'm going to have Mr. Meinkoff go ahead and zoom in on that 1.10 section titled Demised Premises. Mr. Geller, can you read to us the definition of demised premises in this lease?
Demised premises, approximately 18,000 square feet of space in the shopping center and being the space cross-hatched on the site plan, which shall have a minimum of 100 feet of clear interior width.
Let's go ahead and turn to that site plan. Your Honor, permission for my co-counsel to, oh, you have said we don't have to ask permission. I apologize, Your Honor. Mr. Meinkoff, let's turn to Exhibit 12.
No problem.
So, Mr. Geller, based on this diagram, what is the area that you leased?
It is the area labeled chimes.
And is there any sort of marking? We just heard the definition of demised premise. So what is all that cross-hatched areas with the lines going through it?
That is common areas or the not areas that we've leased. Or no, those are the areas that we have leased. I'm sorry.
That's okay, Mr. Geller. So is the area where that red X is within that leased area?
No, it's not. That is outside of that, the crosshatched area.
And where on this diagram did the accident occur?
The X is where the loading dock is. So
is that where that red X is?
yes.
Okay, let's go ahead and turn then to another page in this lease, going to page 9. We're going to zoom in here on the definition of a term we've heard a couple times today, a common area. Mr. Geller, can you read to us the definition of a common area?
The term common area is defined for all purposes of this lease as that part of the shopping center intended for the common use of all tenants, including among other facilities as such may be applicable to the shopping center, parking areas, private streets and alleys, landscaping, curbs, loading areas, sidewalks, malls and promenades, enclosed or otherwise, lighting facilities, drinking.
Great, and let's go ahead and turn then to 6.3. Can you read to us this section titled Maintenance of the Common Area?
The landlord shall be responsible for the good and safe operation, management, and maintenance of the common area. And the landlord shall operate, manage, and maintain the common area in good, attractive, and safe condition during the lease term.
Thank you, Mr. Meinkoff. We can take that down. So, Mr. Geller, whose job was it to maintain the common area where the accident occurred, according to the lease?
That was the landlord's Kermit Realty.
No further questions.
Cross.
Yes, Your Honor. Mr. Geller, you own Chimes Department Store.
I do.
And you've been the owner for the last 10 years.
Yep.
There are no other owners of Chimes Department Store.
No, they're not.
And as the sole owner, you take pride in Chimes.
Yeah, it's my family business.
Right. So you care about its image.
Absolutely. My grandparents started it, so like it's my legacy.
And so with it being your legacy, you don't let your employees smoke out front.
I mean, our customers wouldn't really like it. Secondhand smoke isn't good for you.
Right. You're concerned about where your customers walk in.
Absolutely.
So you send your employees out back to smoke.
If they want to. I'm not making them smoke.
So if your employees are going to smoke, you send them out back.
I require that they do it in the back of the store, yes.
Where you have a landing platform.
Yes, there's a loading dock there.
So let's talk about this landing platform when you first rented this space. You asked Kermit Realty to remove the guardrails from around the landing platform.
Yes, to convert it into a loading dock to bring goods into the store.
Right, and to convert it, you had them remove the guardrails from around the stairs leading up to that platform.
Yes.
Even asked them to build a concrete ramp to the landing platform.
Correct, to make a loading dock.
Right, so trucks could back up and load and unload.
That was required.
And Kermit did it.
They did.
Like you said, never objected.
Nope.
And you paid for those changes.
Yeah.
But you claim the landing area isn't really yours.
But I mean, it's not within my lease.
So that's a yes to my question.
It's not really mine, so it's more than just a claim.
Citing court and opposing counsel what's already in evidence as Exhibit 19. Now, this is a picture of what the landing looks like after you had Kermit Realty make those changes, right?
Yes.
Again, no rails on the landing,
Correct.
no rails on the stairs,
Yes.
and some chipped concrete on those stairs.
I mean, I can't really tell based on this picture what you're talking about. Looks like there's a lot of chipped concrete around.
Now, with this being your store, you've been out back before, right?
I have.
So you're familiar with that area.
I am.
So you're saying now you can't remember if there was chipped concrete or not.
No, I just don't know where you're talking about. I mean, there's chipped concrete all over this. There's chipped paint. Absolutely.
So there's chipped concrete and chipped paint on these stairs and loading dock.
Yes.
Now, you've used that landing for your store since you made those changes, right?
Yep.
Now, your store received deliveries every day.
Usually, yeah.
Deliveries are made to that landing about every day.
Yeah.
Boxes are unloaded onto that landing every day.
Usually, yes.
Your employees usually move those boxes from the landing to inside the store every day.
Yeah.
But you claim the landing area isn't really yours.
I mean, we don't lease it. Anybody else could use it if they wanted to.
So I'm not asking you about your lease. I'm asking you what, as a part of this lawsuit, you have claimed. And you claim that that landing area really isn't yours, right?
I mean, it's not mine.
So again, that's a yes to my question, Mr. Gaylor.
Yes.
You also had your employees do other work on that landing area, right?
Yeah.
You did not leave the cleaning of that landing area to Kermit.
No.
You had your employees clean that landing area.
So that we could use it. Yeah.
Right. Use it to take trash out
Sure.
through that landing area,
Yeah.
down the back stairs.
Yeah.
And to take the trash out, you even put a dumpster next to the landing area.
We did.
This is the dumpster you had placed next to that landing area.
Yeah.
You paid for this dumpster,
Yeah.
not Kermit.
Correct.
In fact, you didn't ask Kermit if you could put it there.
I don't believe we did.
So you just did it.
Correct.
But again, you claim the landing area isn't really yours.
Yes. And
You also require your employees to take their smoke breaks on that landing, like we've already said.
I mean, they could walk off the landing too,
Right, in that landing area.
out in the back. Yeah.
But you claim that landing area in the back isn't really yours.
No, it's common area.
Let's talk about the lighting on that landing platform. There's a light fixture, right?
There is a light fixture. Yes.
Near the landing platform.
Correct.
That light was not automatic,
No.
had to be turned on by a switch.
Yes.
But your employees could not turn it on
No, they couldn't.
because the switch was not in your building.
That's correct.
It was in one of the businesses next to yours.
Correct.
But the switch is now inside your business.
Objection, 407, subsequent remedial measure.
Response?
Your Honor, they originally disputed feasibility as well as control in this matter, and this goes to the control of that outside light, which they exercise by placing this switch inside of their building.
Your Honor, if I may.
You may.
On direct examination, Mr. Geller explicitly testified that it was feasible to have put in a light. We are not disputing feasibility or control over the light switch.
I heard that testimony as well. Mr. Banks, are you saying that at some previous point throughout this litigation, the defense has disputed the feasibility of that measure?
Yes, Your Honor.
Response?
Your Honor, I would need to be pointed to an exact place where we did.
Your Honor, during plaintiff's direct examination, the plaintiff was told by one of this defendant's own managers and agents that they were unable to put that light switch inside of their building because it was not in their space. That alone created a question for the jury to be heard on the feasibility or control of the area and that light switch.
Your Honor, if I may.
You may.
One manager's testify that it was not in control is not the defendant's testimony that it was not in their control. The representative of the defendant, Reese Geller, has stated it was feasible and was in their control. Therefore, it is not permissible under 407 for this measure to come in.
May I be heard, Your Honor?
You may.
And a different agent of this same defendant said that it was not in their control, and we have heard testimony as to such. And this now one agent is saying the opposite. This creates a question for the jury, and it needs to be clarified before going back to them.
If it's been disputed by some employee of the company, I'll admit it at this point. The objection's overruled.
I'll ask you again, Mr. Geller, but that switch is now inside your store.
Yes, we can make changes inside of our store.
Right, and that switch controls the light outside that shines down on the loading dock.
Yes, we, attach the switch to that light.
And you knew that switch to that light was not inside your building before Mr. Gilmore was injured.
Yes.
And because you just said you could make changes inside of your store, you could have put that light in before Mr. Gilmore was injured.
I believe I said before that we could have put a light switch in, yeah.
But again, you did not.
Correct.
Your Honor, permission to approach.
You may.
Based on a motion in limine, Your Honor, we want to discuss the next line of questioning regarding a prior instance of a fall outside on these same back stairs.
All right. Defense?
Yes, Your Honor, I believe he's referring to Exhibit 14 would be the basis for this testimony. And Your Honor, I can have my co-counsel publish that exhibit for you to view if that would help as we're discussing this.
Yeah, I'd like to see it before we get into it.
Great. Mr. Meinkoth, can we go ahead and put up Exhibit 14? So, Your Honor, this exhibit is the basis for this information, and you'll see that at the top it's labeled a recorded statement. So in this document, the manager of the store, in this case listed as April Nardini, was recording the statements of a Jason Stiles. Now, Jason Stiles, while a cashier at the company, was not acting within the scope of his employment as required by 801D2D when making these statements. Therefore, that second level of hearsay under 805 would make this document inadmissible. And without this document, we have a lack of personal knowledge and a lack of foundation for the witness to testify about it.
All right. Plaintiff?
Your Honor, we are not going to go into or admit Exhibit 14, but rather we are going to the knowledge of this defendant, which is relevant to prove the defendant knew or should have known of the unreasonably dangerous condition on the stairs, an element we must prove in today's negligence case. In January 2010 at 7:15 p.m., the same time of day and the same time of year that Mr. Gilmore was hurt, and another employee was hurt on those same dark stairs. The plaintiff is offering this evidence to prove that the defendant knew or should have known of the unreasonably dangerous condition 9 years before this incident even occurred.
Your Honor, if I may.
You may.
As it sounds like counsel is now arguing this for the non-hearsay purpose of notice. The problem is, Your Honor, is that if this document isn't true, then it's not a relevant notice purpose. If April Nardini did not fall, if this accident did not occur, then it does not make a fact of consequence in today's more or less likely, and it is not proper notice. Therefore, it wouldn't be a relevant non-hearsay purpose either.
May I respond, Your Honor?
You may.
Opposing counsel has not shown any lack of credibility in this document or the statements contained therein, and therefore notice, as opposed to the truth of the matter asserted, is permissible for the use of this document.
Your Honor, can I clarify?
You may, but first I want to clarify. I know we've gotten into this sidebar based upon the motion in limine. What is the specific basis of the objection at this point to this particular document? It's hearsay?
Your Honor, yes, hearsay as well. Yes, Your Honor, it is hearsay at this time. It sounds like they're now switching up their reasons. So I might have some different responses depending on whether they are bringing or not bringing in the document, which I'm a little confused by now.
We'll take it step by step. The objection is hearsay. So plaintiff, what is your response specifically to the hearsay objection?
First, Your Honor, my apologies, Your Honor. First, that it's an opposing party statement as it was filled out by an agent, a manager of this defendant's store, and the other portion was filled out by a employee, an agent acting within the scope and line of their employment to fill out this incident report after an incident while the manager was doing the same. And as such, is an opposing party statement by agents.
Do you have a response to that?
Yes, Your Honor. As counsel has hinted at, there's two layers of hearsay here. And while the first, the manager making this report, would fall under 801 D2D, the employee's statement about a fall certainly does not fall within that exception because they were not acting within the scope of their employment. In fact, they were acting outside of their job as a cashier and making this report. So that second layer of hearsay is the problem, Your Honor, and it does not fall under an exception.
All right. Anything further from the plaintiff before the court rules?
Yes, on that, Your Honor. This defendant required all employees, cashiers included, to report any incidents that they suffered on the job site. And that is exactly what this line of questioning that is based loosely on this document goes into, Your Honor, and therefore, again, is not hearsay. It is opposing party statement made by an agent acting within the scope and line of their employment.
The objection to hearsay is overruled. Are there any further objections to this particular document?
No, Your Honor, not at this time.
All right. Then Mr. Banks, you may proceed.
Yes, Your Honor. I ask you again, Mr. Gaylor, this was not the first time one of your employees was hurt in the dark on those stairs, right?
No.
On January 8th of 2010, an employee was injured going down the stairs.
I'm not sure about the date again. You'd have to show me, but I believe it was like January 8 or 12 or something like that.
So in the early part of January of 2010, an employee was injured going down the stairs.
Yes.
And that employee was injured around 7:15.
Again, I don't recall the time.
Your Honor, permission to refresh the recollection of the witness, Your Honor.
You may.
And permission to constructively share screen with the witness.
You can share screen with the witness physically.
We're looking at Exhibit 14, which is the base of your knowledge on this, Mr. Gale. And look at that bottom part, accident/loss header. And look up at me when you're refreshed on the time at which this incident happened.
Yeah, the report says 7:15.
Thank you, Mr. Davis. So again, that employee was injured at 7:15.
Yes.
After the employee fell on slipping on loose concrete.
I believe that's what happened.
In the dark.
7:15 p.m. sounds like it was dark. Yeah.
With no railing to grab onto.
Yeah.
Now, as a part of the investigation into that incident, the Chime supervisor who conducted the investigation made a recommendation.
Sure.
The Chime supervisor working for your store recommended that Chimes should make sure there is adequate lighting on the loading dock, right?
Yeah, I believe that was a recommendation.
Do I need to show you Exhibit 14 again, Mr. Geller?
No, I mean, that's what I recall the recommendation being.
But again, Chimes did not make sure there was adequate lighting on the loading dock after that incident.
I mean, it was Kermit's job to do so.
And you did not make any suggestion to Kermit that change needed to happen.
I don't recall making any suggestion to them, no.
And that's the same light switch you say you moved into your store.
Sure, we found a way around it to do it.
Without Kermit's permission.
Correct.
Jordan Gilmore was injured in January of 2019.
Yes.
At 7 p.m.
Around then, yeah.
After slipping on the landing platform.
I mean, yeah, that's what he says happened.
while walking up the stairs
Again, yeah, that's what he says happened.
in the dark
That's what he says happened.
with no railing to grab onto.
There was no railing there. I can tell you that.
So that's a yes to that there was no railing to grab onto, right?
Yes.
Pass the witness, Your Honor.
Any redirect?
Yes, Your Honor.
You may proceed.
Mr. Geller, after that incident in 2010, could you, as Chimes Department Store, the lessee, could you have installed a guardrail?
Now without permission from Kermit Realty.
Could you have fixed the concrete?
Again, not without permission from Kermit.
At any point prior to Mr. Gilmore's accident, could you have installed a guardrail?
Without permission of Kermit.
At any point prior to Mr. Gilmore's injury, could you have fixed that concrete?
Again, we would need permission from Kermit.
And did the light, did it illuminate a common area or a leased area?
That's Kermit's area, so it's a common area.
No further questions, Your Honor.
Any recross?
Yes, Your Honor. Mr. Geller, you said you couldn't make any of these changes without Kermit's permission, right?
That's correct.
And to take down those railings, you asked Kermit.
Correct.
And they did it
They did.
without hesitation.
Yeah.
And you paid for it.
Objection
Right.
asked and answered.
Overruled.
So back in 2010, after the prior incident, you did not ask Kermit to put up guardrails.
No,
Did not ask Kermit to put up handrails.
we didn't.
Did not ask Kermit to fix the concrete.
Nope.
And in 2019, you did not ask Kermit to put up handrails.
Correct.
Did not ask Kermit to put up guardrails.
I don't know what the difference is, but yeah,
Did not ask Kermit to fix the concrete.
correct.
You did not ask them to fix the light switch,
Nope.
but you did it.
Did what?
You fixed the light switch,
Yes, we did.
but you did nothing outside on that landing area
Correct, because we
because
couldn't.
you say you couldn't do it without permission.
That's correct.
Nothing further.
Any redirect?
No, Your Honor, I don't believe another redirect is permitted in this forum unless I'm incorrect. So
I was instructed that you are actually allowed to redirect if you feel it's necessary beyond a single redirect and recross. But if you have nothing further, that's completely okay.
nothing further,
Right.
Your Honor.
All right, thank you. The witness is dismissed. Defense, do you have any further witnesses?
Yes, Your Honor. At this time, we call Perry Hayden to the stand in the form of a deposition.
All right.
Whenever the court is ready.
Proceed.
Directing the court and counsel's attention to page 2, line 5. Good afternoon. Can you please state your name for the record?
Good afternoon. My name is Perry Hayden.
Line 9. Where do you live?
I live in Austin, Texas.
What do you do for a living?
I am a compliance, safety, and health officer with the Occupational Safety and Health Administration.
Line 22. And what did you do at OSHA as a compliance, safety, and health officer?
I'm one of the people from OSHA that goes out and inspects workplaces on a regular basis to see if that workplace is in compliance with OSHA standards.
Line 16. How long have you worked for OSHA?
Since I got out of school, so at this point, it's been about 13 years.
And over that time, how many inspections have you conducted?
Oh man, hundreds, thousands. I mean, the answer is a lot. It's basically my entire job. So I'm always out on the road inspecting somewhere. It's an everyday thing.
Page 5, line 1. Are you paid by anyone for your time here today?
Nope.
Line 6. All right, Mr. Hayden, how are you involved in this case?
Well, I conducted an inspection at the Chimes department store in Waco back in 2018. So I assume that's why I'm here.
Mr. Hayden, I'm showing you what's been marked as Exhibit 36. Do you recognize this?
Yes, this is my report from 2018 inspection of the Chimes department store.
Is Exhibit 36 a true and correct copy of the report regarding your 2018 inspection of the Chimes department store?
Yes, it is.
Moving to page 6, line 8. Did you issue any citations to Chimes as a result of your inspection back in 2018?
No, I did not.
Did you inspect the area behind the store where there's a little landing area and some steps?
Yes, I did.
Page 6, line 22. When you went out there, what did you notice about the steps in that landing area?
Well, at first I was a bit alarmed because there were some pretty obvious issues.
Like what?
Well, there were stairs and a landing area, but there were no guardrails anywhere. Plus, the concrete on the edges of those steps and that landing area were cracked and eroding away.
If there were, line 9, I apologize. If there were such obvious safety issues, why didn't you issue any citations?
As I said, I got pretty alarmed. So I asked the manager that was walking around with me during the inspection about the fact that there were no guardrails and about the cracked concrete. The manager told me that there used to be guardrails, but they were removed because Chimes used that area as a loading dock.
Why does that matter?
Because loading docks don't have to have guardrails.
How do you know that?
Because OSHA says so.
Page 8, line 20. Is there any OSHA regulation that does specifically discuss loading docks?
Yes, 1910.28B13 clearly states that guardrails aren't required on loading docks because they aren't feasible. You can't very well load something onto a dock with a bar in your way.
Page 9, line 1. Have you had a chance to review the deposition of Kelly Danes?
Yes, I have.
Well, what do you have to say about all of the OSHA regulations that Kelly Danes testified were violated by the defendant because of the condition of that landing area in the back of the store?
I'm sure Ms. Danes is a very nice person, but they're just reading those regulations too broadly. None of them deal with loading docks, which is what Chimes was using this area as. This wasn't just a stairwell or just a landing area at the top of a stairwell. This was a loading dock, and the provisions cited by Kelly Danes don't deal with loading docks.
Was this area behind the store exclusively used as a loading dock?
No, it's my understanding that employees also went out there to throw trash in the dumpster and to take breaks. And it is certainly possible that employees went out there and did other things as well. But I don't think that matters.
Why not?
Well, just because an employee goes out and sits on the edge of a loading dock and eats a sandwich doesn't make that loading dock a diner. The key thing here is that Chimes used this area as a loading dock, and that's what matters.
No further questions, Your Honor.
Cross,
Yes, Your Honor.
you may proceed.
Directing court and counsel to page 62, page 6, line 22 through page 7, line 15. When you were out there, what did you notice about the steps in that landing area?
Well, at first I was a bit alarmed because there were some pretty obvious issues.
Like what?
Well, there were stairs and a landing area, but there were no guardrails anywhere. Plus, the concrete on the edges of those steps and that landing were cracked and eroding away. Someone with half as much experience as me could look at that and see some pretty obvious problems.
If there were such obvious safety issues, why didn't you issue any citations?
As I said, I got pretty alarmed, so I asked the manager that was walking around with me during the inspection about the fact that there were no guardrails and about the cracked concrete. The manager told me that there used to be guardrails, but they were removed because Chimes used that landing area as a loading dock.
Citing court and counsel to page 10, line 3 through page 11, line 3. Is Exhibit 38 a true and correct copy of that email?
Yes, it is.
Do you disagree with the assessment?
Objection, Your Honor. This is a portion of the testimony that we agreed to meet at sidebar about before addressing.
Okay, proceed.
Yes, Your Honor. So what we're getting into in this testimony is the Exhibit 38 email that I addressed, as well as Exhibit 39. And we're about to get into whether he disagrees with the assessment of the boss in the email. All of the information in here is that performance review evidence that, one, is inadmissible hearsay. Two, would be irrelevant and misleading to the jury given that there were never any disciplinary actions filed. We have no way to confirm or deny whether any of this was well-founded. For all we know is a misunderstanding. And third, Your Honor, it would be used for the inadmissible purpose of arguing that because he had had an improper evaluation at one time, he didn't do his job well at this time. So pursuant to 404, it would also be barred.
Response?
Yes, Your Honor. As to relevance, this goes to the credibility of this witness, and that is always relevant at trial, Your Honor. As to 404 and conformity, there is no conformity issue here, Your Honor. We are not arguing that because of some prior review that there was a poor review based on this performance. That is not the argument here, Your Honor. However, we are going to show this as credibility on this witness and the job they potentially did or did not do in accordance with it related to that. And lastly, as to hearsay, Your Honor, we are not admitting exhibits 38 or 39 as a part of this.
Your Honor, if I may.
You may.
Multiple responses. First, Your Honor, our objection was not relevant. It was 403, misleading the jury. But Your Honor, second of all, they don't get to hide behind credibility as an argument to backdoor in 404 character evidence. This evidence doesn't go to credibility. There's no evidence that this means we can't even confirm that this would mean that he is or isn't a good inspector because there were no disciplinary actions. This is the exact problem with 404 evidence, Your Honor. And second, just because they aren't admitting the exhibits, they're still seeking to admit the statements of the boss. That's still inadmissible hearsay.
Response?
Yes, Your Honor. As to opposing counsel related to 404, all of that is within the selected portions that will be read aloud and goes to the weight rather than the admissibility. All opposing counsel's concerns go in the back and forth and call and answer, and therefore the jury can hear this testimony and weigh that in their consideration of this expert and his opinion, Your Honor. And as to hearsay, Your Honor, this would not be used for the truth of the matter asserted.
What is it used for then in that instance? If not the truth of the matter asserted, what is it offered for?
My apologies, Your Honor, I misspoke. It's a business record as it's kept regularly in the course of the evaluation of an OSHA employee, which this witness was at the time.
Have we heard the testimony for that particular foundation?
No, Your Honor, that's coming in this subsequent line of readouts.
Right. And what is your response to the 403 objection, the substantially more misleading than probative?
Your Honor, this does not confuse the issues for the jury, but rather, again, goes to the credibility of this witness, and any potential prejudice is not, one, unfair and is not outweighing the probative value, Your Honor. If anything, worst case scenario, these are evenly matched and should come in, again, for the jury to consider and considering the testimony of this expert.
Okay. At this point, I'm going to sustain the objection. If you'd like to lay foundation for the other purposes for which you've said that you're going to use this evidence, you're free to offer that foundation. But at this point, the objection is sustained.
Citing Court and Counsel's page 11, line 16 through 12 at 5. Did you ever inspect that area behind the store at night?
No, only during the daytime.
Did you notice a light out there when you were doing your inspection?
I did. You'll see it noted in my report.
Did you ask the manager about that light?
I did, like you can see in my report.
And what did the manager say?
Manager told me that they always turn the light on when somebody goes out back at night, so that seemed good enough for me.
Did you have them turn it on for you while you were there?
No, didn't seem necessary.
This time, Your Honor, a statute that was referenced during the course of this testimony, we seek to read that out loud for the jury at this time.
Okay.
OSHA 1910.28B13. When the employer can demonstrate that the use of fall protection systems is not feasible on the working side of a platform used at a loading rack, loading dock, or teaming platform, the work may be done without a fall protection system provided the work operation for which the fall protection is infeasible is in process, access to that platform is limited to authorized employees, and the authorized employees are trained in accordance with 1910.30. Move to preserve this as plaintiff's demonstrative A, Your Honor.
So preserved.
Pass the witness.
Nothing
you
further from the
redirect?
defense, Your Honor.
All right. One moment and we can proceed into closings. Actually, would y'all like a break before closings? All right. We've got time for a 5-minute break.
Thank you.
All right. The court is in recess. All right, do the parties close on the evidence?
Yes, Your Honor.
Yes, Your Honor.
And are there any further motions to take up before we proceed to closings?
Your Honor, for the record, we would renew our Rule 50 judgment or motion for a directed verdict, but for the sake of time, we can just lie on our previous record.
All right, that's fine. And it is still overruled or denied. All right, plaintiff, are you ready to proceed?
Yes, Your Honor.
All right, the floor is yours.
May it please the court. Some people want all the control and none of the responsibility. This defendant wanted all the control over the landing area behind their store. They wanted their employees to keep it clean, to pick up the trash on it, to unload merchandise, to load merchandise on it, to use it to take out the trash out of the store, to the store's dumpster right beside it, to send employees outside to smoke on it. They wanted all of that control over the loading dock, but none of the responsibilities that came with that control. Members of the jury, you are here today because Jordan Gilmore was injured. Because he was injured due to the negligence of this defendant, Chimes Department Store. Because Jordan Gilmore was injured, we have brought a negligence claim against the defendant. And when we brought this claim, we took on the burden of proving to you that it is more likely than not that the conditions of Chimes Department Store caused Jordan Gilmore's injuries. In order to meet our burden using the evidence, we've had to prove to you three things. First, that the loading dock area of Chimes Department Store posed an unreasonable risk of harm. Two, that Chimes Department Store knew or reasonably should have known of that danger. And three, that Chimes Department Stores failed to exercise ordinary care to protect Jordan Gilmore from the danger by both failing to adequately warn Jordan Gilmore of the condition and failing to make that condition reasonably safe. We have met our burden today. But let's talk about how. Kelly Danes told you that the defendant failed to comply with the International Building Code and OSHA standards for guardrails and other standards to maintain a safe environment for employees. Responsible for maintaining and free from recognized hazards. Look at the condition of this landing and these stairs. Not only no guardrails, but the concrete is crumbling. Jagged edges, door swinging out over the stairs, all easily recognized hazards. Responsible for making sure there's adequate exterior lighting. Any means of egress is to be illuminated at all times when the building is occupied. In other words, if folks are inside that building, any exit has to be well lit. The defendant had a light outside on the landing, but it was never turned on, and it was never turned on that night. The door on Chimes' loading zone was not up to code. Under IBC 1005.2, when the door swings open, it should not cut more than halfway into the path of someone walking. Look at this. Someone does not need a physics degree or an engineering degree to figure out that this door swings out a whole lot more than halfway into the path of travel. This is just another failure by Chimes to provide its employees with safe conditions. Defendants try to throw that off on Kermit Realty, but after this incident, they had a switch to control that light installed inside their building. It was feasible for them to have controlled that light before Mr. Gilmore fell. They just chose not to. And even though we had Mr. Danes tell you the legal reasons why this landing was unreasonably dangerous, we don't need an expert to tell us that this landing with its crumbling concrete, no guardrails, and in the pitch black of dark is unreasonably dangerous. It's common sense. We learned today that the defendant has been in this building for 15 years and that the defendant had the guardrails that were previously on the landing area removed. We have proven that the defendant knew the landing area was unreasonably dangerous. But members of the jury, it gets even worse than that. We also proved that this defendant knew for 10 years just how dangerous the stairs attached to their loading dock were. This defendant knew that back in 2010, an employee fell onto the same stairs at the same time of night and in the same month And when that was brought to their attention, Chimes knew just how dangerous the loading dock and stairs were, but they did nothing. For 10 years, they did nothing because according to Mr. Gaylor, fixing those stairs and providing a safe area for their employees, an area where they normally sent their employees, was not their job. Despite the fact that Chimes recommended to themselves that there be a light added over their stairs. Nothing for 10 years. We've also proven that the defendant failed to exercise ordinary care by failing to adequately warn Mr. Gilmore of the condition and failing to make the landing reasonably safe. We've seen all the pictures of the landing and the doors leading to that landing. Now, what we did not see in any of those photos, no warning signs, no sign saying watch your step, no sign saying danger, no sign saying caution, no warning signs at all. We also know that the defendant did not do anything to make the landing reasonably safe. After tearing down the guardrails 15 years earlier, the defendant did nothing to make the landing safer. In fact, we learned today that after Mr. Gilmore fell and went back inside the store, the defendant's manager told Mr. Gilmore that he had warned the defendant about the stairs in the past, but the defendant never repaired the stairs. They always had bigger problems to fix first. Which brings me to the last thing that the evidence has shown you today, that the defendant exercised control over the landing. Judge Pfeiffer will tell you that for the defendant to be liable, they must have control over the area and that a tenant, like the defendant, is responsible for areas it leases and those areas adjacent to the leased area which it actually controls. But how do we prove control? Judge Pfeiffer will tell you that the control can be proven by an actual exercise of control. And we learned today that the defendant exercised control over the area from the very beginning. First, the defendant instructed Kermit Realty to remove the guardrails and to build a concrete drive leading up to the landing. The defendant paid for those changes. That's control. Next, the defendant used the landing as a loading dock. The defendant admitted that he had trucks making deliveries to the store and using that landing almost every day. That's control. Next, the defendant put in a separate dumpster right next to the landing without ever asking Kermit Realty if they could. Control. The defendant required their employees to use the landing to take the trash out. Control. The defendant required their employees to clean out the landing and the surrounding area. Control. The defendant required their employees to smoke outside on the landing and in the surrounding area. Control. The defendant exercised control over the landing area, and their negligence was the proximate cause of Jordan Gilmore's injuries. Judge Pfeiffer will tell you that the proximate cause is a substantial factor in bringing about an injury, and that without that cause, the injury would not have occurred. Without the defendant having an unreasonably dangerous landing, this injury does not occur. The complete disrepair and lack of guardrails on the landing was a substantial factor in Jordan Gilmore's injury, and it was absolutely foreseeable that someone could and would fall off that landing or off those stairs. The defendant was negligent, and the defendant's negligence caused Jordan Gilmore's injury. The defendant said over and over that the area where Mr. Gilmore was injured was a loading dock. Their expert said that meets the requirements of the IBC to have a loading dock, that under the statute, it didn't need rails. But what the IBC actually said, Mr. Davis, is that three things had to be met. Because when the employer can demonstrate the use of a guardrail or travel safe restraint system is not feasible, the work may be done without those systems provided. The work operation for which the fall protection is infeasible is in process. Mr. Gilmore was out on a smoke break, not loading or unloading merchandise, but on a smoke break. A's not met. B, access to the platform is limited to authorized employees. And based on Mr. Gaylor's own words, it's a common area. No, he didn't have control of it, so anybody could be back there. The expert said that they could eat a sandwich back there without issue. B, can't be met. And C, the authorized employees are trained in accordance with 1910.30. And for Mr. Gaylor, the representative for this defendant in today's case spoke nothing on any employee training. So C can't be met. None of the requirements to not have rails on a loading dock were failed to be met by this defendant. Some people want all the control and none of the responsibility. This defendant wanted all the control over the loading dock behind their store. This defendant took all the control of the landing area, but they wanted none of the responsibility that came with that control. The Judge Pfeiffer will give you a verdict form, just like this one, Mr. Davis. Now, the first question is, did the negligence, if any, of those named below proximately cause the occurrence or injury in question? For Kermit Realty, answer no. If you answer no, case is done. But after today's evidence, we know that in the case you prove yes and you mark yes, we go to the second question. Because if you answer yes to Kermit Realty, you will then have to assign a percentage of responsibility to Kermit and the defendant. And because the defendant exercised actual control over the landing area, assign the defendant at least 90%. But after the evidence today, we know it wasn't Kermit because the defendant had every opportunity to ask Kermit for this to be done, but they didn't. Their prior request, as soon as they asked, Kermit hopped on it. But they didn't. For 10 years, the defendant is responsible for the unreasonably dangerous condition of the landing area and responsible for the injuries Jordan Gilmore suffered. Find this defendant responsible.
Your Honor, I just would like to make a brief record that those were not the jury instructions we're dealing with today. Those included Jordan Gilmore, which are not the ones we're using today. So just for the sake of clarity.
Great. Thank you. And thank you, Mr. Banks. Defense, are you ready to proceed?
Yes, Your Honor. Okay. Whenever the court is ready.
You may proceed.
This case is about the failures of a corporation. But it's not about the failures of Chime's department store and the good men and women that work there. It's about the failures of Kermit Realty, the property group that was in charge of and was in control of the area in question. Now, members of the jury, I'm putting this up right away because this is the first question you have to answer today. This is the question that will be on your jury form. Before you get to any of the stuff Mr. Banks talked about negligence and ordinary care and all that, you have to answer this question. Who had control of the area? Who had control of the stairs and the guardrail out back? Now, I want to be very clear about what Mr. Banks is arguing today and what he just told you. What Mr. Banks has argued today is that use equals control. Well, let's break that down. Let's talk about what that would mean if that were true for premises liability cases. You drive across the highway, right? On occasion, maybe in an Uber, maybe in your own car. you come across a pothole. Maybe you swerve and miss it, or if you're like me, you usually run straight through it. But regardless, is your first thought to call up your state department or whoever's in charge of your roads and let them know, oh, there's a pothole here? If you're like me, that's not really a thought that crosses your mind. Why? Because you've made an agreement. You pay taxes, and in return, they keep the roads safe. Now, under Mr. Banks' theory, though, let's be very clear about what he's arguing. He is arguing that since you use that road and you have used that space for whatever purpose you've used it, if you don't call and report that pothole, oh, you're now liable for anything else that happens because of that pothole. Another car gets into an accident, another axle is damaged. So I think it's called an axle. I'm not really familiar with cars, but regardless, members of the jury, think about what that would mean. When you use a space, that does not mean you have control over the space. When I use the stairs in my law school, if I come across a crumbling steps or a condition that looks unsafe, I don't feel compelled to call my administration and say, you need to get out here. And certainly it would be unfair to then hold me liable for any injuries that happened because of that. Why? Because I was not in control. Members of the jury, Chimes department store isn't trying to play some games and say, oh, well, we could have called, we should have. Members of the jury, that's not logical. Mr. Banks' argument makes no sense. We have decided as a society that whoever owns and controls a property has the job of maintaining that property. It's not the users of the property's job to call up and report everything that's wrong with it. Why? Because that wouldn't work. Think about it, members of the jury. Think about how many spaces you use on a daily basis that you don't own or control. If you're like me, it's a lot. I guess during COVID, it's gone down quite a bit, but generally speaking, it's a lot. And if it was your job to report every single potential safety violation that came up in there, well, we couldn't function. That's not how we as a society have decided premises liability works. That is not fair. That is not fair. And that's why the problem with today's case is that Chimes department store was the wrong party. The plaintiffs rushed into this lawsuit and they chose the wrong defendant. They chose the party that didn't have control. You see, Kermit Realty was the one who wanted all the control and none of the responsibility. Mr. Banks is right. Kermit Realty wanted the ability to approve of the removal of the guardrails. They wanted to do the removal. They wanted all the control of that back area. But they took none of the responsibility. Members of the jury, use is not control. Before we go any further, I want to talk about this issue of these OSHA regulations or IBC regulations. We've heard a lot of mention of them today, but I want to be very clear. These OSHA provisions, they're a distraction. The judge in today's case will tell you what the law is that you're applying. And surprise, you're not applying OSHA regulations today. It's not your job to determine whether they violated OSHA or not. And remember, Mr. Hayden, well, he works for OSHA and he went out there and determined there were no citations to be made. Members of the jury, that is why today's case comes down to Kermit's negligence. It would be absolutely unfair to tell Chimes department store today that, oh, that area you had no control over, you used it, but yeah, you couldn't have removed or put in a guardrail. Oh, that was your fault. That's on you. It's like telling me, oh, that's on you that someone else got into an accident because of that pothole. You didn't report it. You didn't ask about it. That's on you. Members of the jury, that's not how our system works. That's not fair. So let's turn to Kermit's negligence. The good news here is me and Mr. Banks, we agree. Everything he just came up here and said about the stairs being in crumbling repair, well, that's unreasonable risk. The fact that there was no guardrail, that's unreasonable risk. We don't even have a debate about that today. Good news. Further, members of the jury, Kermit knew of that risk. It was easily seen from miles away, maybe not miles. But you saw from the pictures today how noticeable that was. Members of the jury, that was the unreasonable risk. That was the risk that Kermit knew about and did nothing for. That was the risk that Kermit Realty failed to exercise ordinary care for. So let's look at what caused this fall. Because you see, we seem to have come up with three elements in today's case: the light, the guardrail, and the concrete. And we agree the light switch, the switch to that light, was within the feasible means for Chimes department store to install. We aren't going to deny that today. We're going to own up to that. We're going to own up to that fact. But what you've heard today is that that light switch, that lack of light, that's not what caused Mr. Gilmore's fall. Let's take a look at some exhibits we've seen today. See, this is that photo of the stairs and the diagram that we went through with Mr. Gilmore. Now, if we chop this off, we can see that is the area that Mr. Gilmore said he needed to step around when going upstairs. Now, he told us he had been in that area 10,000 times or more. There's at least 10,000 times. I don't know about you, but I get pretty familiar with an area when I've been there about 10,000 times. I know the turns, I know the angles. I can usually do it with my eyes closed. So what caused him to fall in an area that he had been 10,000 times before? Well, it was the factor that was ever changing over his 10 years there. It was the factor that Kermit Realty ignored. It was the factor that Kermit Realty failed to exercise ordinary care with, and that's that concrete. That disintegrating concrete that every time an employee walked up those stairs continued to be worn away. And then to top it off, there was no guardrail, so that when that concrete slipped out from underneath him, or when he wasn't familiar with where the concrete had disintegrated any longer because it was changing over time, he couldn't catch himself. No guardrail, no concrete. That is what we've showed you caused Mr. Gilmore's fall. Members of the jury, Chimes department store was not allowed to install the safety precautions that were required here. That was not their role in this lease. Now, again, you're going to have the lease with you when you go back there. It'll define the common area. It will tell you, contrary to what Mr. Banks said in his closing, that Kermit Realty had agreed to maintain that space. But that's not the only evidence we saw today. Mr. Banks wanted to talk about who exercised actual control. He's right. That's a valid piece of evidence for you to look at today to determine control. But that's the key distinction here, members of the jury. Use is not control. Remember the potholes. It's not fair to hold Chimes department store responsible for something that was not in their control, that according to their lease, Kermit Realty had said, "I've got this." Because Kermit Realty wanted all of the control and none of the responsibility. Members of the jury, Kermit Realty has met the three elements of negligence today. They have failed to exercise ordinary care. They were aware of and allowed that dangerous condition to develop. They knew about it, or reasonably should have known about it. Members of the jury, the good news here is, again, me and Mr. Banks agree. He just argued a lot of this for me. The condition of those stairs was not good. We aren't disputing that today. What we're saying is, under premises liability, we've decided that as a society, you have to hold the person responsible who had control of that space, not just use. So I want to go ahead and turn to the jury instructions that you'll be seeing today after we leave this room. You see, this is the first part of your jury instructions. And for this part, you'll be asked to state yes or no to whether either of these parties' negligence proximately caused Mr. Gilmore's injuries. Now, here's the key, members of the jury. We've shown you that Chimes department store was not the party who controlled that area. And if that is true, you have to state no. If Chimes department store did not have control of that area, they cannot be held responsible. They cannot be found negligent for that injury. But we have shown you that Kermit Realty, not only in their lease, but through their actions, exercised control over that area. And they have met those three elements of negligence. So we ask you to write yes. But let's say you disagree with me. Let's say you're sitting there and you're saying, look, that light, I think that was a problem. Chimes should have installed that light. Well, we aren't going to disagree with you there. And if you find that persuasive from what Mr. Banks has told you, they should have installed that light switch, and you find that that may have contributed to his injuries, that's okay. When you get to the percentages portion of this, you'll be asked to assign a percentage of fault. And at that point, you can say, well, Chimes department store, they should have installed that light. And maybe you think they should have asked for the guardrail to be out. Maybe that's what you think. Maybe you are the person that reports every pothole you find. Well, then you can find them 10% liable if that's what you believe today. But you have to find Kermit Realty the other 90%. Why? Because they had control of the space. They knew of that unreasonable risk. They ignored that unreasonable risk. Members of the jury, this case today is about control. And that is why at the end of this trial, we ask you to find Chimes not liable. Remember the potholes. Kermit was in control. Thank you.
Thank you. Plaintiff, any rebuttal?
Yes, Your Honor.
You may proceed.
The defense mentioned Kermit all throughout this case today. But we as the plaintiff are focusing on the person that is actually here to defend themselves, that has a voice today. But the defendant wants you to focus on an empty chair, somebody without a voice, without somebody here to fight for them. But they want to tell us about what's fair. What fair is bringing Kermit to court because they could have done that. And if they really believe the way they talk, they should have and would have brought Kermit to this court. If they believe that Kermit was so responsible, Kermit would be sitting right next to them at that table. But they're not, because the defense knows that at the end of the day, it was their client, Chimes Department Store, that exercised control over that area and had every duty to make sure that their employees, just like Mr. Gilmore, stayed safe. Defense also tried saying that if we saw a pothole on the interstate, that it's our duty to report it. We have no duty. We did not create the pothole. The difference is the State Department does not send anyone onto that road to use it, but the defendant on daily basis to load and unload, to take smoke breaks, to take out garbage, and to come back inside and do it all over again, sent their employees to that dock and to those stairs to a condition they created because they asked their landlord to take them out and paid for it. They paved and laid concrete up to that loading dock and exercised control over that entire area. OSHA places a duty on employers to keep their premises safe. And while the defense wants to tell you that OSHA and the IBC codes are here to distract you, the thing is that those are what reasonable companies do in this same position. OSHA and the IBC lays out what is reasonable for similarly positioned defendant companies, just like Chimes. And every single one of those things we have shown you today, Chimes has violated. They were negligent. They are responsible, and they were in control. Find the defendant solely responsible.
All right, the case has been submitted to the jury. I'm going to give the jurors a moment to fill out their ballots and to get those in. If everyone can please stay in the room. And I understand that we'll be able to give a couple of comments briefly once all of the ballots are in, but let me get confirmation from the tab room that all the ballots are actually in before anyone starts with comments. All right, the tab room has said that all of the ballots are good to go. So all of the ballots are in, and the judges can please turn on your cameras and introduce yourselves. But while everyone's coming up, I will say that was a great job, everybody, to both of the teams. Y'all are fantastic. I mean, it's clear to see why y'all are at this competition. I know it's a very daunting competition. Y'all don't have a lot of time to prepare, but y'all have done very, very well with the time that y'all have had. And so congratulations to both of you. All right. Miss London, would you like to start us off with the comments?
Sure. So these are going to be super brief, and assuming that you guys pull the same side again, which I don't know whether that's realistic or not, but maybe they'll help you on the other side. Plaintiff, a little bit of thought on depositions. So there was one instance in which the same line was read by defendant, and then you read it again on cross. I just don't know if that's the best use of your time, but one thing that I would love to see that would be a great use of your time would be introducing your witness with name, background, and why we care about them at the top of the deposition. Both parties don't feel bound to go in order as long as you roadmap where you're going if there's a way to tell your story. Defendant, when you were on cross, there was a moment when I wanted you to just go ham and we let it go. So let me just toss this out here. You asked the question about the quote that the owners had other things to work on. And you were in this line of questioning about things that he didn't know about. That would have been an amazing opportunity to sell your whole theory. You don't know if one of the things they had to work on was the fact that they needed to go work with the management company. You don't know what that relationship with the management company was. Like, take 10 questions there and deliver your close. That's what I got. Y'all were wonderful.
Thanks. Mr. Marty.
You were wonderful. It was a great round. I do understand why Top Gun is actually a Top Gun tournament. Just a couple of comments. Mr. Banks, this is my pet peeve, but I also know it's shared by many other folks who judge these contests. I don't like catchphrases like, you want all the control and none of the responsibility. I think you can work that into a sentence that says the same thing, but doesn't sound quite as contrived. Now, again, that's my pet peeve, but I've judged dozens and dozens of rounds, and I've always said that, and I've never been listened to. So maybe you're the first. Ms. Nickel, once in a while I would see a facial expression that indicated maybe disappointment or disagreement with a ruling. You need to learn to be totally unflappable, completely stoic about the rulings. You know, even happy when you're losing a ruling. Act like you're happy. Anyway, and I noticed this is just a technical issue, and I hope this goes away in the very near future. But when you were in opening statement and closing argument, you shifted to this mode where it's a different mode in Zoom apparently, and the words got behind your lips, by a couple 3 seconds, and it's a little distracting. You might check the tech on that, but otherwise, y'all are splendid. I enjoyed listening to both of you.
And Mason?
Yeah, great round. Don't have very many comments. This goes for both of you. I think just verbiage, I would refer to Kermit as the landlord, because nobody likes landlords, but everybody likes a green frog named Kermit. And so just from how to drum up how bad this empty chair is, just refer to him as the landlord, as this, mystery party who isn't responsible and isn't coming to court to face up to what they did. And I didn't, for defendant, only constructive thing for you, I did not like the analogy of the pothole in the highway. Because this is so much more close to control within an employee-employer environment. Like, it's a loading dock that they use. Like, kind of own up to that. Don't try to liken it to something that is completely out of your control with like a pothole. So just kind of, it's a bad fact for you. So just kind of own it and don't try to distance yourself from it like a pothole or something. But overall, very good round.
I agree. I thought the storytelling on both sides was very good in this round. But I also agree with Judge Jones, Marty Jones, about facial expressions on both sides. I want both of you to just make sure you catch yourselves. I think I saw it on both sides as well at different points, but it's easy to, it's reflexive. And so it's harder, I guess, is what I need to say. It's harder to actually control those facial expressions because of the reflex. But it's noticeable, especially more noticeable in this Zoom format than it probably would be in courtrooms. And so you're front and center for the whole 2 hours. And so you just have to keep that top of mind. But I thought the witness control was also very good on both sides too. You had a question, you made sure it got answered. That's pretty much all I had. Great job for both sides. Chris, do you have any comments as well?
Yeah, I'll keep it short. One thing that y'all can both do, and this is coming from someone who competed at undergrad and law school mock trial. If you're trying to score higher on those ballots that we got, a next level move that both of y'all can do is try and incorporate your themes in the direct exams and the cross exams. And don't just try and incorporate your theme, use the other opponent's theme against them. Now, both of y'all did a great job in the openings and closings in arguing those themes and helping illustrate your theory of the case. But that, for me, completely went away in the case in chief for both sides. And so, like I said, that's a next level move that when I'm judging these things, when I can see a competitor do that, I know that's for me, that's the truest sense of thinking on your feet and arguing the case in the room right there, is adapting to what the other side is going to do for their theme. So I would just say both y'all can do that better, and that'll help you score higher.
Thank you all very much for your feedback. We really appreciate it and your time on this Saturday morning.
No problem. All right, that's all I have. I will leave the trial running, but everyone is free to go. You are dismissed.
Thank you.
Thanks, John, for a great round.
You too.
Good luck, y'all.
Thank you.
Good afternoon.
Good afternoon, Judge.
How are you?
Outstanding.
Good. I was just letting in all the scoring judges. At home, happy on your couch. I got to see Professor Powell, so it was worth it. And can I tell you, he's so relaxed and shiny and bright.
He's retired now, right?
I know. He's just like, I don't even know what day it is. I just walk around and smile at everyone in the hallway. So he is super happy. All right. I think I was told I've got to keep this. It would make sense. Gallery view. Camera. Okay. I'm supposed to hide y'all as non-video participants. Let's see. Turn your right on. Oh, y'all have got your ballots and everything?
Yeah.
Okay.
Yes.
Okay, good.
And we'll turn off our video too.
Okay, great. Thank you. Okay. They're making me keep track of time on my phone. That'll be great. I've only got 2 of the competitors in the waiting room right now, so I'm gonna, although they may have their, oh no, that's only 1 team. Okay, so I'm gonna wait till I have all of them before I let them all in. So we shall just hang out. I'm gonna stop your video, Will. Stop video and I'll mute you. There you go. Oh, I'm going to send y'all my cell phone number in the chat. I guess that's what Judge Pfeiffer did earlier. So that if anybody gets knocked off or you need anything, just call me on my cell phone. Just a question for in the meeting, I have a witness guest. Is that one of plaintiff's witnesses or defense witness?
It's both.
It's both. Okay, perfect. So when they call you, then you just unmute and appear. Okay, that's great. All right, thanks. Just wanted to make sure. Thanks so much. It is now 3 o'clock and I do have all of the participants in the waiting room, so I'm going to let them in. Good afternoon, everybody.
Good afternoon.
Good afternoon. Sorry, renaming myself. Too many buttons.
That is okay. All right. One thing, just for some preliminary matters, I have put in the chat my cell phone number. So if anything happens where you get logged off and I can't get you back in, don't hesitate to call. There are additional scoring judges that you can't see. They are on Zoom right now, but they have muted and hidden their video. And then I did check and your witnesses are ready and in the waiting room for when you call them in. Okay, well, let's get started. We are on the record. This is cause number TG-CV-001-21, Jordan Gilmore versus Chimes Department Store, Inc. Would counsel please announce themselves for the record, starting with plaintiff?
Yes, Your Honor. Rebecca Nickel on behalf of Ms. Jordan Gilmore today, along with my co-chair, Mr. Philip Meinkoth.
Thank you.
Good afternoon, Your Honor. My name is Jack Ayers, appearing on behalf of the defendant, Chimes Department Store. I also want to introduce my co-counsel, Regina Campbell, as she'll be handling all of our technology today.
Good afternoon, Your Honor.
Good afternoon, and thank you. We have 5 minutes each side for any pretrial matters. Does plaintiffs have any pretrial matters that they wanted to submit to the court?
Yes, Your Honor, just briefly, we did come to some stipulations with opposing counsel prior to coming to trial today. And that is firstly, Your Honor, to pre-admit 3 exhibits.
All right, which exhibits are those?
2, 5, and 19. At least those are my notes. Mr. Ayers, please correct me if you have different notes.
Were you wanting to use exhibit 4 in your opening statement as well?
Yes, I wasn't sure if you had received my email. I did switch it out just in case. So if we are able to pre-admit that, great, and then we can go from there.
We have no problems with the pre-admittance of 2, 4, 5, and 19.
Great.
Thank you. Exhibits 2, 4, 5, and 19 are admitted. Any additional matters that you needed?
No, we are ready to proceed to substantive motions at this time, Your Honor.
All right. Any other housekeeping for you, Mr. Ayers?
Yes, Your Honor. Once an exhibit's been admitted into evidence, may we have permission to publish it, or would you prefer that we ask each time?
No, you have, once it's submitted, you can publish it.
And I also just wanted to alert the court that we've met and conferred regarding the various versions of the jury instructions. The operative version of the jury instructions will be version 4, starting on page 33 of the case file.
Very good.
That's it in terms of housekeeping, Your Honor. We're ready to move on to substantive stipulations as well.
Thank you, Ms. Nickel. You can go ahead.
Yes, Your Honor. And first, to provide the court some context, this case is about Miss Gilmore. And on January 23rd, 2019, Miss Gilmore was out taking a break at the area designated by her employer as the break area when she slipped and fell and suffered permanent injuries due to hazards that the defendant created and chose to ignore. Now, we have conferred with opposing counsel as to our 2 motions. I believe we're in agreement as to both, but we want to make sure we have a clear record for the court as to what will not be discussed today.
Thank you. Go ahead.
As to our first motion, Your Honor, we seek to include or pre-admit in this case an Exhibit 36 as an exception to hearsay under 8038, a public record. This is a report created by the OSHA investigator that will be here today by deposition. So we would ask to admit that into evidence now pursuant to that exception to hearsay.
Any objection?
No objections, Your Honor.
Exhibit 36 is admitted.
And second, Your Honor, we seek to exclude any legal interpretations of a lease involved in today's case between the defendant, Chimes Department Store, and the plaintiff and the property owner, Kermit Realty. Specifically, a Miss Geller will be here to testify today as the owner of the department store. And while she certainly has knowledge of her own beliefs of that lease, any legal interpretations of those terms would be improper expert testimony under 701 and 702.
Any objection?
No objections, Your Honor.
All right, thank you. And her testimony on those matters are excluded.
Thank you, Your Honor. And we are ready to proceed to opening statements once defense has had a chance to do any substantive motions.
Thank you. Mr. Ayers, your substantive motions.
We were also able to meet and confer and agree with opposing counsel before trial as to exclude as irrelevant and unduly prejudicial any testimony regarding the circumstances surrounding the plaintiff's job loss. So this includes the fact that she may have been fired according to her deposition, or that she could no longer work due to her injuries. The fact that she no longer works for the defendant, my client, is obviously allowed and admissible, or we have no issue with that. But the fact that the circumstances surrounding how she lost her job, we've agreed will not be testified to today.
Is that correct, Ms. Nickel?
That is correct, Your Honor. The fact that she was unemployed is all that we will be seeking to admit today.
Okay. And anything else? Mr. Ayers?
Nothing from the defense, Your Honor.
Very good. All lawyers would work all that out before they started. Every trial would be so much better. All right, we can all dream. All right, very good. Let me read, and I apologize that I am needing to take time on my phone. So if I need to pause for a second, we will do that. I'm sure you're both aware, because you've already had a round, that you have 55 minutes for total case. And are you wanting me to give you any of a countdown at any time? And we can wait until you get further in to see if you want to count down for closing or something like that.
Yes, Your Honor, a time check at halftime and a time check right before closings would be sufficient for us, if that's okay with Mr. Ayers.
That's perfect for us as well, Your Honor.
Very good. Scrolling to 55 minutes. We are ready. Are you ready to proceed with opening statement, Ms. Nickel?
Yes, we are. I'll just need a brief 30 seconds to set up my well.
Okay. All right. Just tell me when you're ready and I'll start the timer.
Can you see and hear me all right now, Your Honor?
I can.
Thank you. Almost forgot to unmute. That would have been problematic. Okay. Whenever the court is ready.
I'm ready. Go ahead.
On January 23rd, 2019, Miss Gilmore stepped out into the shadows, but what she didn't know is that there were hazards hidden by the shadows, hazards that her employer had ignored, hazards that led to her slipping and falling and permanently injuring herself while on a break at work. Members of the jury, let me paint you a picture. Because today's case is about exactly that. It's about the hazards hiding in the shadows. But let's look at the scene of this accident involved in today's case. This is the location where Miss Gilmore was taking her smoke break on January 23rd, 2019. She worked at Chimes department store as a cashier. And this was the location that her employer had designated, required her to go for those smoke breaks. So on January 23rd, 2019, not unlike some other days, she stepped outside onto that landing, onto this platform, and proceeded to walk down the stairs. She made it to the bottom. She hung out. She took her smoke break. She chatted with a fellow employee that was outside with her, and then proceeded to go back inside. But this is where things went wrong. You see, as she stepped up those concrete stairs, you'll notice that the edges of those stairs are deteriorating. So as she stepped up and reached that top landing, she slipped. And normally there would be a guardrail to catch her fall, but there was no guardrail there. She crashed to the ground and suffered serious and permanent injuries to her knee. Now, these hazards, the ones in this photo, they're dangerous enough during the daytime, but at least during the daytime you could see, because I left out one fact about when Miss Gilmore went outside on January 23rd, 2019, and that was that she went outside at night. So instead of looking something like this, the scene looked more like this. Members of the jury, there was no light provided by Chimes department store outside where they required their employees to take that smoke break. The hazards that were hidden by the shadows. Now, let me introduce you to Miss Gilmore, the plaintiff in today's case, the one who's brought this lawsuit. Miss Gilmore was a loyal employee of Chimes department store for over 10 years. She worked as a cashier. She knew the customers well. She enjoyed greeting them, checking them out. She enjoyed her job, and she did it well. When her employer told her to do something, she did it. She certainly wouldn't want to get in trouble. But you see, Chimes department store didn't hold up their end of the bargain. Chimes department store didn't make a work environment that was safe. Chimes department store created a hazardous condition. Now, as we're going through trial today, I ask you to pay close attention to three issues. Specifically, I asked you to pay close attention to notice, risk, and choices. Now, at the end of this trial, we'll connect this to the elements of the offense charged today. But these are the three key issues that I want you to pay close attention to. Let's start with notice. Did Chimes department store have notice of an unreasonable risk? That's the question that will be posed to you today. Now, the evidence will show that Chimes department store not only knew that the concrete was deteriorating, not only knew that there was no railing to catch anybody when they fell, not only knew that they sent their employees out there at night, not only knew that, but knew there was no light for them to turn on in the case of it being dark. They knew that. They also knew that this was a dangerous location. Because listen closely, members of the jury, that wasn't the first time something had happened out there. So look for those facts today. Look for the facts that show that the defendant knew that this was an unreasonably dangerous location and yet did nothing. But let's talk next about risk. Because members of the jury, the defendant also knew of the risk that they created. There's going to be three components at issue today that could have all contributed in some form or another to Miss Gilmore's fall. You see, we have the concrete that was deteriorating, we have the lack of the railing, and we have the light. But we're going to ask you to pay close attention to that light. The fact that there was no light outside. Members of the jury, that, along with the fact that the defendant knew there was no guardrail and knew that the stairs were falling apart, that was the risk that the defendant created. And please listen closely, because it was as simple as installing a light switch. Had the defendant simply installed a light switch, we will show you today that Miss Gilmore would not be here. That was the risk that they created. That brings us to choices. You see, the defendant made choices. They made choices not to take precautionary steps that would have avoided the injuries that Miss Gilmore suffered. Their choices, specifically their choices not to take those steps, well, they forever impacted Miss Gilmore. But again, members of the jury, I ask you to pay close attention to the defendant's choices, because you will be asked today, what is the magic number of injuries? Members of the jury, how many people have to be injured on the defendant's property before they take the simple step of installing a light switch? That's what I want you to be thinking about at trial today. How many times do they have to send their employees out there? How many times do they have to pose that risk before they install a simple light switch? That is what we will pose to you, is would have avoided this whole mess. Now, as the plaintiff in today's case, we have the burden. We have the burden to prove to you by a preponderance of the evidence, meaning more likely than not, that it was the defendant, Chimes Department Store, and their actions, or in this case, lack thereof, that led to Miss Gilmore's injuries. And we embrace that burden. Because at the end of this trial, you will see that it was as simple as a light switch. That's all it would have taken, members of the jury. So look for that. Look for the evidence that showed that the defendant knew there was an unreasonable risk, that they had created that unreasonable risk, and that they chose to ignore it. Because it's all about the hazards hidden by the shadows, members of the jury. So at the end of this trial, I will come back before you and I will review all of the evidence with you. And I will ask you to find the only verdict that aligns with justice in this case. I will ask you to hold Chimes Department Store accountable for the injuries that they caused Miss Gilmore. Thank you.
Thank you. Mr. Ayers, your opening.
May I proceed?
Yes.
Just because there's a fall doesn't mean there's fault. So Tuesday evening in January, the plaintiff, Jordan Gilmore, she's out on a smoke break behind the building where she works. She takes out a pack of Marlboros, taps the bottom, pulls out a cigarette and lights it up. She closes her eyes, enjoys her break. So she hears her manager shouting her name. Break's over. It's time for her to get back to work. So she stubs out her cigarette, and she throws it in the dumpster. And she starts back up those stairs. It's 5 steps. She gets to the top. She puts down her foot on that final step. She walks inside. Just like she did the day before. And the day before that. And the day before that. For 10 years. Members of the jury, the plaintiff told you those stairs were dangerous. They told you a dramatic story about hazards hiding in the darkness. They told you the corners were bad. They told you there was not enough light. They told you there wasn't a railing. But the evidence will show that the plaintiff had walked up those same steps under those same conditions thousands of times before. With no injury, no incident, no accident. The evidence will show that these stairs, they've been approved by a federal safety inspector. The evidence will show that on January 23rd, 2019, Miss Gilmore fell not because there was a problem with the steps, but because she tripped. And she tripped because sometimes people trip. Just because there's a fall, it doesn't mean there's fault. And now in their opening statement, the plaintiff tried to talk about Reese Geller. That's the owner of Chimes department store. But I want you to meet her. Miss Geller, would you turn on your camera? This is Reese Geller. She hasn't always been the owner of Chimes department store. Her grandfather started the business. She had a single storefront right here in Waco. When he decided he wanted to retire, her dad took over. And when her dad retired, she took over the business. She's owned it for 10 years now, but she'll tell you that for 3 generations, her family have been taking care of their customers and taking care of their employees. Thank you, Miss Geller. And now as the defense, we don't have to prove that. We don't have to prove anything. We have no burden of proof. And it's important that you understand that. That burden, it lies with the plaintiff and the plaintiff alone. They have to prove their case, every single element, more likely than not. But there are 2 elements of their case they won't be able to prove today. They won't be able to prove that the conditions outside Chimes were unsafe. And they won't be able to prove that the conditions outside Chimes caused Miss Gilmore's injuries. Let's take those one at a time. The first element of their case that they won't be able to prove is that the conditions outside of Chimes were unsafe. You see, the plaintiff didn't mention this in their opening statement, but less than a year before Miss Gilmore's accident, well, Chimes was inspected by an OSHA inspector. OSHA, that stands for Occupational Safety and Health Administration, and they are the federal body in charge of workplace safety. You'll hear from the OSHA inspector who came to Chimes, who spoke to the manager. You hear she went through those doors, went up those stairs, went down those stairs, same as the plaintiff. Her conclusion? This was a safe place to work. These stairs, well, they were a safe place to walk. When it comes to safety, the proof is in the pudding. The evidence will show those stairs were safe. You'll learn that Miss Gilmore, she started working at Chimes in 2010. She liked her Marlboros, and so for 10 years, she smoked on her smoke breaks outside the back of the store. When she was done, she'd throw away her cigarette butt in the dumpster out there. To get down to that dumpster, she'd walk down the stairs. To get back from that dumpster, she'd walk up the stairs. You learn that over the course of those 10 years, Miss Gilmore walked up and down those stairs literally thousands of times. Before January 23rd, 2019, she didn't slip, she didn't fall. In fact, she'll tell you, she never even had a problem. I do want to be upfront with you. One of Chimes's employees has fallen on those stairs before. That's true. But you'll learn, members of the jury, that was in 2009, before the plaintiff lost her footing. People went up and down those stairs for a decade. The cashiers, clerks, managers, delivery people, anyone who wanted to smoke, they'd all use those stairs. People taking out the garbage would use those stairs. And in the decade between that solitary other fall and when Miss Gilmore lost her footing, no one fell. No one was hurt. That brings me to the second element of their case that the plaintiff won't be able to prove today. The plaintiff won't be able to prove that the conditions outside Chimes caused Miss Geller's injuries, Miss Gilmore's injuries. As you listen to the testimony today, I want you to pay particular attention to the plaintiff's testimony, because we suspect there will be a gap between what the plaintiff's attorney just told you in their opening statement and what their client actually testifies to on the stand today. They told you, they said multiple times in that opening, you'll learn that if the defendant had just installed a light switch, none of this would have happened. But when you listen to Miss Gilmore, she's not going to tell you that in the dark, she missed the step. They told you those steps were in disrepair, but when you listen to Miss Gilmore, she's not going to testify that the stair crumbled beneath her feet or that she lost her balance because the steps were uneven. And when you listen to Miss Gilmore, what she'll tell you is she walked down those steps, smoked her cigarette, and started back up. She got to the top of the steps, and then she put her foot down on the landing. Didn't just put it over the landing. She put her foot down. And then something happened. Members of the jury, that's what Miss Gilmore will tell you. That something happened. She won't be able to tell you what that something was. And she certainly won't be able to tell you that that something was caused by Chimes department store. I want to make sure that this is clear. We are not trying to blame Miss Gilmore. People slip, people trip, people fall. That's normal. But we're asking that you not blame Chimes department store either. Because the evidence will show that those stairs, they passed a federal inspection. The evidence will show those stairs, they were used thousands of times across 14 years without issue. At the end of this trial, we will ask you to find Chimes department store not liable. Just because there's a fall, it doesn't mean there's fault. Thank you.
Thank you. Ms. Nickel, you can call your first witness.
Yes, Your Honor. At this time, we call Ms. Jordan Gilmore to the stand.
Okay. Hello, Ms. Gilmore. Can you please raise your right hand for me? Do you solemnly swear or affirm that any testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right. Thank you. You can put your hand down, and Ms. Nickel, you can proceed.
Thank you, Your Honor. Good afternoon now, Ms. Gilmore. Can you please state your name and spell your last name for the jury?
Yes, my name is Jordan Gilmore, spelled Gilmore.
Ms. Gilmore, we know you're the plaintiff in today's case. So why have you brought this lawsuit?
Well, I was at work when the accident happened. I fell off of the loading dock in the back of where I used to work, which was Chimes department store. And after that fall, my knee was really messed up and I had to get a knee replacement entirely, which was a whole process that.
Objection, Your Honor, under Rule 403 and relevance. May I be heard outside
Yes.
the presence of the jury?
Yes.
Your Honor, this case has been bifurcated, and liability is the only portion of the case at issue here. For this witness to testify that this was a whole process and to go on any further about how that knee affects her today is irrelevant and substantially more prejudicial than probative under Rule 403.
Your Honor, if I may respond.
Yes.
I didn't intend for this witness to go any further, but to establish the minimum that we have to establish today, which was that she was injured and those injuries are permanent. We are not taking it any further than that.
All right. The objection is overruled and you may proceed.
Thank you, Your Honor. So, Ms. Gilmore, we left off with your injuries. Are those injuries permanent?
Yes.
Objection, Your Honor, under Rule 403.
The objection is sustained. Go ahead.
Ms. Gilmore, let's learn a little bit more about you. Where are you from?
I'm from Waco, Texas.
And what do you do for a living now?
Now I don't do anything. I'm unemployed.
And we're obviously here because of Chimes department store. So did you previously work at Chimes?
I did.
And what did you do for Chimes?
I was a cashier.
And how long did you work for Chimes?
About 10 years.
So let's talk about what happened on January 23rd, 2019. You mentioned that you slip and fell, but I'm going to go ahead and have my co-counsel publish what's already been admitted as Exhibit 19 so we can see more clearly what happened that day. So is this the location where you fell?
Yes, it is.
Can you describe to the jury in more detail what happened that day?
Well, I was working at Chimes. It was January. It was cold. I was working the evening night shift, and around 7 o'clock, I took a smoke break, which I had done basically every day that I was at work, at least once. I went out to the back, which is what you see in this picture here. I went with a coworker of mine, Riley. It was dark at that point. I walked down the stairs to smoke a cigarette. About 5 minutes later, I headed back up the stairs. Riley was standing in the doorway. She had the door open just enough that light could come out and kind of illuminate that area for us. And as I was coming back up the steps on about the last step there, when I put my foot down, it slipped. I lost my balance. I fell off of that highest platform. I tried to catch myself on both feet, but most of my weight ended up on my right foot, and I ultimately fell all the way down to the ground. My leg hurt, my hip hurt. Riley came down to help me. She asked if I needed an ambulance. I told her no. We went back inside. I told my boss that was working there that night, the manager.
Objection, the witness has lapsed into a narrative.
Sustained.
So Ms. Gilmore, let's go ahead and break that down. I'm going to have my co-counsel publish a demonstrative that we previously entered into evidence. Thank you. Now, Ms. Gilmore, you described it as being dark. Was there any source of light outside that night?
Yes, there was light coming from inside.
So I'm going to go ahead and have Mr. Minecoth put up 3 arrows from the direction you described. And Ms. Gilmore, if at any point this demonstrative no longer reflects what happened that day, please let me know. So the light was coming from inside. Where is the door on the demonstrative?
It's that part of the demonstrative that's labeled door.
We'll have Mr. Minecoth highlight that in red. Now, Ms. Gilmore, as you were going up those steps, about where did you have to stand to get around that door?
About the furthest part of the steps from the building, closest to the edge.
I'm going to go ahead and have Mr. Minecoth put a circle up around those stairs close to that edge. So when you were in that area, were you able to utilize the light from inside the building?
Not really, no.
I'm going to have him close out that circle in black. Now, Ms. Gilbert, were there any other lights outside?
There was a light on the other side of those stairs.
I'm going to go ahead and have Mr. Gilmore put up a yellow circle to the right of the stairs on this demonstrative. Is that about where that light was?
Yes.
And was that light on?
No, it was not.
Could you have turned it on?
I could not know.
And why was that?
There wasn't a light switch for that light inside of our store.
Now, if you could have turned on the light, would the area that is right now marked by the black circle, would that have been illuminated?
Yes, I believe so.
I'm going to have Mr. Meinkoth remove that black circle. Does this fairly and accurately reflect what occurred that day, Ms. Gilmore?
Yes, it does.
Then, Your Honor, at this time, we would preserve this demonstrative as defense demonstrative 1 for future use.
Any objection?
No objection to its preservation as a demonstrative, no.
Okay, thank you.
Thank you. I'm going to go ahead and have Mr. Meinkoth now turn to what was previously admitted as Exhibit 4. So, Ms. Gilmore, was this location, the corner of that step, was that where you had to step that night to get inside?
Yes, it is.
We can go ahead and take that down, Mr. Meinkoth. Now, I want to turn to why you were out at that location in the first place, Ms. Gilmore. You had mentioned earlier that you were outside on a smoke break. Had you been a smoker for long?
Yes, I had.
And how many cigarettes a day did you smoke about?
About a pack a day.
So about how many times a day did you go outside for a smoke break?
At least once whenever I was at work on a shift.
And why did you go to that location specifically?
They told us to go there.
Now, I want to go ahead and take a look at an exhibit then. Can you turn to Exhibit 1 in your packet?
Yes, I can.
Let me know when you're there.
I have it pulled up.
Do you recognize this exhibit?
I do.
What is this an exhibit of?
This was a memorandum that was sent from my manager, Miss Kim, from the Chimes department store to all of the employees that worked there about where we needed to go if we were going to have smoke breaks.
And does it fairly and accurately reflect that email?
Yes, it does.
Then, Your Honor, at this time we move Exhibit 1 into evidence.
Any objection?
No objection, Your Honor.
All right, Exhibit 1 is admitted.
Thank you, Mr. Meinkoth. Can we go ahead and publish that? I'm going to have Mr. Meinkoth zoom in onto this second half of the first paragraph. Can you read for us, Ms. Gilmore, starting at "as you have"?
Yes. As you have been told before, if you are going to smoke, you need to smoke out behind the store where the dumpster is. That is the only place you should take smoke breaks on the premises.
Thank you, Mr. Meinkoth. We can take that down. Now, if you had quit smoking, could you have avoided going into that area?
No.
Why not?
Well, the dumpster is back there too, so whenever I would take the trash out, I would go that way to throw it away.
No further questions, Your Honor.
Thank you. Readjusting the time.
Of course, Your Honor.
Defense counsel, you can proceed.
Thank you. Good afternoon.
Good afternoon.
Can you see and hear me clearly?
I can.
I want to start by talking about those stairs behind the store. January 2019, that wasn't the first time you used those stairs, was it?
No, it was not.
You started working at Chimes department store back in 2009?
Around that time, yes.
A policy at Chimes, as you just said, was that smoke breaks, they should be in the back of the store.
Yes,
You followed that policy.
I did.
You would walk out the back door.
Yes,
You'd walk out onto that platform, right?
I would.
Down those stairs.
Sometimes, yes.
That's where you'd smoke your Marlboros, right?
Yes.
So let's get a sense of how many times you actually took those stairs. Now, you told us on direct examination that you took a smoke break at least once a day, right?
Yes, when I was working.
But you also told us that you went back there for trash, to take the trash out, right?
Yes.
Your Honor, may we display a calculator as a demonstrative aid?
Any concern or objection by plaintiff's counsel?
So, Your Honor, we discussed this pre-trial and I have no objection to it.
All right. Yes, then you can go ahead.
Ms. Gilmore, can you see that calculator?
Yes, I can.
So between the smoke breaks and the times when you'd take out the trash, you'd say that you went outside and took those stairs 20 times a week, right?
Give or take.
You were a full-time employee, right?
I was.
So you'd work about 50 weeks a year?
Yes.
Every time you took those stairs to take out the trash or to take a smoke break, you'd walk down the stairs, right?
I'm a little confused by your question. I'm sorry.
Let me rephrase. When you had to take the trash out, you had to walk down the stairs, right?
Yes, for the trash.
When you took your smoke break, you'd also walk down the stairs, right?
Sometimes I would stay on the top platform like Riley did that night.
Okay. But when you were taking the trash out, then you'd have to walk down the stairs.
Yes.
And sometimes you'd also go down the stairs when you took your smoke breaks.
Yes.
And when you did walk down the stairs, you also had to walk back up the stairs.
Yes.
So for each of those 20 or so trips a week, well, that was actually 2 trips on the staircase, right?
Yes.
You worked at Chimes for 10 years.
Yes, I did.
Ms. Gilmore, it's fair to say you took those stairs thousands of times, right?
Yes.
On direct examination, you told us what those stairs looked like.
Yes,
You told us about the lighting.
I did.
You told us there wasn't a guardrail.
Yes.
But for every one of those thousands of times that you took the stairs were in roughly the same condition, right?
I believe so. I'm not too sure.
Well, you were the one taking the stairs, right?
Yes, but over 10 years, I'm not sure how much those stairs really changed. It's quite a long time.
So you can't remember there being a significant change in the conditions of those stairs.
Not a significant change, no.
You can't remember a minor change either.
Not off the top of my head.
In every one of those thousands of times that you walked on those stairs before, you never hurt your knee.
No.
You never fell off those stairs.
No.
You never got hurt on those stairs.
No, I didn't.
In fact, for the thousands of times that you walked down and back up those stairs, you never had any trouble at all before January 2019, right?
Right.
So let's talk about the day you were hurt. You said you went outside around 7:00 p.m.
Yes,
It was dark out.
it was.
This wasn't the first time you took a smoke break at night, though, was it?
No,
The outside light, that was off.
it was off.
But you and your friend, you kept the door open.
A little bit, yes.
Is it your testimony you only kept the door open a little bit?
I didn't keep the door open. My friend Riley was the one holding the door open.
Okay, but you saw that diagram that opposing counsel showed you, right?
I did.
You said that's the way the door was open, right?
Yes.
It wasn't open just a sliver.
No.
It was open.
Yes. Those doors open all the way, though, and it was not open all the way.
But it was open 90 degrees.
Yes.
You used the light from inside the building.
Yes.
This wasn't the first time you'd done that either.
No.
You walked down the stairs using the light from inside the building.
Yes.
You were able to see well enough to make it down the stairs.
Yes.
You didn't fall.
No.
You didn't slip.
No.
So let's focus on what caused this accident. Once you got to the bottom of the stairs, that's when you smoked that cigarette.
Yes.
When you were done, you threw away the cigarette butt.
I did.
You started back up the stairs.
Yes.
It's 5 steps, right?
Yes, it's 5.
And at the top of the steps, there's a landing platform.
There is.
You put your foot onto the landing platform, right?
Yes, my right foot. Yes.
That's right. Your right foot only, right?
Yes.
You didn't miss the landing platform.
No.
You didn't just touch the landing platform with your right foot.
No.
You planted your right foot onto that platform.
My foot was on the platform. Yes.
And then, in your own words, something happened and you slipped, right?
Yes.
You can't tell us what that something was.
No.
You don't recall the concrete giving way underneath you.
I'm not sure.
Well, you don't remember there being any loose concrete that you skidded on.
No, I don't.
You don't recall any water on the stairs.
I don't.
In the 10 years that you worked for Chimes, this was the first time you ever had any problems with those stairs?
I guess you could say that.
It's not what I would say. I'm asking what you would say. And you would say that in the 10 years you worked for Chimes, this was the only time you ever had any problems on those stairs, right?
Yes.
Thank you. No further questions.
Thank you. Any redirect?
Yes, Your Honor. Miss Gilmore, why did you have to go out back on those stairs in the first place?
Well, that's where we were on. That was the only place we were allowed to take our smoke breaks.
And were you required to be there for any other purposes?
To take out the trash. That's where the dumpster was.
And for all those 20,000s of times, were you always outside in the dark?
No.
And for all those 20,000s of times, was the door always blocking the inside light?
No. Like I said, it opened all the way.
No further questions, Your Honor.
Any recross?
No recross, Your Honor.
Thank you. May this witness be excused?
Yes, Your Honor.
And well, she's the plaintiff, so she's going to be staying around. But okay, so you can call your next witness.
Thank you, Your Honor. We now called Kelly Danes by deposition. Directing the court and counsel to page 1, line 6. Good afternoon. Can you please state your name for the record?
Good afternoon. My name is Kelly Danes.
Line 12. Tell us about your education.
I have a bachelor's of science in mechanical engineering from the University of Wisconsin-Madison.
Since graduating from college with your mechanical engineering degree, have you gotten any further education?
Sure. I've attended various seminars offered by the National Academy of Forensic Engineers.
What do you have to do to become a professional engineer?
Well, you have to graduate from an accredited engineering program, which I did. Then you have to pass the Fundamentals of Engineering exam, which I did. Then you work as an engineer for 4 years before you take the professional engineering exam. So I took that as well, and I passed.
Moving to page 4, line 14. Over the course of your career, how many incidents have you investigated?
Over 60,
How many times have you been deposed?
about 20,
And how many times have you testified at trial?
twice prior to this.
Moving to page 5, line 14. All right, Kelly, I want to move on and talk about your work in this case. What did you review in coming to your opinions in this case?
I reviewed the deposition of Jordan Gilmore, the deposition of Reese Geller, a number of different regulations from the Occupational Safety and Health Administration, a number of provisions from the International Building Code, and I conducted an inspection of the location of the fall and took pictures of that area.
Moving to page 8, line 16. Okay, what opinions have you come to in this case?
First, the International Building Code and the regulations from the Occupational Safety and Health Administration apply to the stairs and landing in question, and the facilities in question must be in compliance with those codes and regulations.
Page 9, line 9. All right, so which portions of the IBC codes and the OSHA regulations did you find important in this case?
First, the general duty clause in the OSHA regulations, which can be found in 29 USCS 654, and the maintenance provision under section 3401.2 of the IBC.
Why are those significant in this case?
These are general provisions that require an employer and/or the party that is responsible for maintaining a building or structure to keep that building or structure in a safe and well-maintained condition, free from recognized hazards. Here, as you can see from the photographs that I took during my inspection of the stairs, the broken off concrete, the lack of stair railing, the lack of railings on the platform, the door blocking the pathway, and the lack of a light switch to turn on the light above those stairs were all hazards that should have been identified with a simple and effective safety program. But the defendant didn't have such a program and never identified or corrected these hazards.
Page 11, line 6. What other portions of the IBC codes and the OSHA regulations did you find important in this case?
OSHA 1910.37B1 and IBC 1006.1, which both deal with lighting.
Why are those significant?
Well, 1910.37B requires that lighting must be adequate and appropriate for a building exit like this one. And 1006.1 requires that any means of egress must be illuminated at all times the building is being occupied. In this case, there was a light above those stairs, but there was no switch for the light inside the Chime store. So there was no way for employees to turn that light on when they went outside at night. A switch like that should have been installed long before the incident to make sure that employees could see where they were stepping.
No further questions, Your Honor.
Thank you. Are you doing any cross by deposition?
Yes, Your Honor. Starting on page 4, line 11. Question. Have you ever worked in code enforcement at any level of the government?
No, I've always been in private practice.
No further questions, Your Honor.
Your Honor, at this time, the plaintiff rests and is ready to proceed to either break or if we have any halftime motions.
What would you prefer? Do you want to do your motion now and then take a break?
Yes, Your Honor. We have one motion. I don't know if the plaintiff has any.
Okay. All right. We are outside the presence of the jury. Defense counsel, you have a motion that you'd like to bring up in front of the court. Go ahead.
Yes, Your Honor. We move for judgment as a matter of law under Rule 50 of the Federal Rules of Civil Procedure. Even viewing the evidence in the light most favorable to the plaintiff, no reasonable jury could find that the plaintiff has met its burden. We focused on the element of causation. The plaintiff presented evidence that the injury occurred at the work site, but not that it was because of the work site. In the plaintiff's own words, I stepped on the landing, something happened, and I fell. Something happened is insufficient to establish causation and therefore liability. The defense requests judgment as a matter of law.
Response?
Yes, Your Honor. The standard in today's case is that we have the burden to prove this evidence by a preponderance, more likely than not. We have shown evidence today that Miss Gilmore had to step outside in the dark onto an area of step where the concrete was falling apart with no railing to protect her. A reasonable juror could absolutely find that it was more likely than not that that fall was because of any number of one of those conditions: the lack of light, the falling apart concrete, the lack of railing. And for that reason, we ask that this motion be denied.
Thank you. The motion for directed verdict is denied. We have 32 minutes and 44 seconds remaining for plaintiff and 35 minutes, 29 seconds remaining for defendant. It is 3:52. So let's take about a 10-minute break. If y'all can come back a little bit after 4, around 4:02, we'll get started again. Thank you very much.
Thank you, Anna.
Thank you.
Thank you, everyone. Before we go back on the record, I do want to do the juror shout out. So I just want to can y'all please unmute when I call your name, just so I know you're there. Mr. Williams.
Here, Your Honor.
Thank you. Mr. Thomas.
Here, Your Honor.
All right. And Mr. Zive. Did I say that right? Do we have, I may have mispronounced your name. Mr. Zive or Zeev, do we have you back? All right, one more shout out for Mr. ZIVE juror. If you are there, if you can please unmute, just so I know you're there. Okay, we will wait a little bit longer. All right, one more time, Mr. Josh Zeev, if you can hear us, can you unmute just to check in so that we know you're there? Mr. Zeev, are you there? All right, I'm going to go check with my bailiff. We should have cell phone numbers for all of the jurors that are participating. So give me 1 second. If he pops back in, I will see him shortly, but one moment. Oh, did we get you back? Mr. Zeev?
Yeah, I'm here. Sorry.
Okay, great. My bailiff, Robert Little, is texting you right now. So just wanted to make sure.
Oh, yeah, Bobby will find me.
All right, very
I don't want
good.
him tracking me down. All right, I'm here.
Okay, great. Thank you so much. You can, yes, good. You've muted and did your video again. All right, we've got everyone back. Let's go back on the record. I'm bringing back up my clock. And defense counsel, you can call your first witness.
Your Honor, the defense opens its case with the deposition testimony of OSHA Inspector Hayden Perry. As opposing counsel did, we'll be reading from the deposition. I'll be asking the questions, and my co-counsel, Ms. Regina Campbell, will be providing the answers.
Thank you. You can proceed.
Beginning on page 2, line 22. Question: and what do you do at OSHA as a compliance, safety, and health officer?
I am one of the people from OSHA that goes out and inspects workplaces on a regular basis to see if that workplace is in compliance with OSHA standards.
Moving to line 16 on page 3. Question: how long have you worked for OSHA?
Since I was out of school, so at this point, that's about 13 years.
Moving now to line 6 on page 5. Question: all right, Ms. Hayden, how are you involved in this case?
Well, I conducted an inspection at the Chimes department store in Waco back in 2018. So I assume that's why I'm here.
Moving to line 20 on the same page. Question: so were there any complaints that led to this inspection?
Not that I'm aware of. I went out there because it had been a while since we had been there. That's it.
Now moving to line 8 of page 6. Question: Did you issue any citations to Chimes as a result of your inspection back in 2018?
No, I did not.
Did you inspect the area behind the store where there is a little landing area and some steps?
Yes, I did.
No further questions, Your Honor.
Thank you. And plaintiff's counsel, you're across.
Yes, Your Honor, we will be picking up right where Mr. Ayers left off on page 6, line 14. Why did you inspect that area?
At the beginning of every inspection, I ask the representative for the employer to outline for me all the areas where their employees work. When I asked that question to the manager at Chimes that day, they told me that employees regularly worked in that area behind the store and took smoke breaks there. So once I had that information, I made sure to include it on my list of areas to inspect.
When you went out there, what did you notice about the steps and that landing area?
Well, at first I was a bit alarmed because there were some pretty obvious issues.
Like what?
Well, there were stairs and a landing area, but there were no guardrails anywhere. Plus, the concrete on the edges of those steps and that landing were cracked and eroding away. Someone with half as much experience as me could look at that and see some pretty obvious problems.
Moving to page 10, line 5. Do you disagree with the assessment of your boss in this email?
No, I don't. I am fairly conservative when it comes to issuing citations. Look, I obviously believe that workplaces need to be safe for employees, but that doesn't mean the government should be draconian in enforcing those regulations, especially in times like these when it's hard enough to find a job or a place to work. So maybe I'm a little bit more lenient than other inspectors. That's certainly possible. But I do my job and I do it well. And we talked about this issue and it was all good. It's not like I've been fired or anything.
Page 11, line 16. Did you ever inspect that area behind the store at night?
No, only during the daytime.
Did you notice a light out there when you were doing your inspection?
Yes, I did. You'll see it noted in my report.
Did you ask the manager about that light?
I did, like you can see in my report.
And what did the manager say?
The manager told me that they always turn the light on when somebody goes out back at night. So that seemed good enough for me.
No further questions, Your Honor.
Thank you. Any more direct?
No, Your Honor.
You can call your next witness.
The defense calls Reese Geller.
4342. Good afternoon, Ms. Geller. Can you please raise your right hand for me? Do you solemnly swear or affirm that any testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can put your hand down and you can proceed.
Good afternoon.
Good afternoon.
Can you see and hear me clearly?
Yes.
Please introduce yourself to the jury.
Hello, my name is Reese Geller, and I'm from here in Waco, and I'm a mom and wife.
You said you're from Waco. Do you still live in Waco?
Yes.
How long have you lived in Waco?
My whole life, I grew up here in Waco.
Where did you go to school?
I graduated from Baylor back in 1998.
What do you do for a living now?
I own the Chimes department store. It's my family's business.
I want the jury to understand what Chimes is. How long have you owned it?
I've owned it for the past 10 years.
Who owned it before you?
I took over from my dad.
Who owned it before your dad?
My grandfather did.
What kind of store is Chimes?
Well, we're a small department store. We sell clothes, shoes, tools, everything.
And where is Chimes located?
We're located off of Bosque here in Waco.
How long has Chimes been in Waco?
We've been in Waco 5 year. Excuse me. I don't remember when we moved to the location at Bosque.
Would looking at your deposition help refresh your recollection of that?
Yes.
In your deposition, could you turn to page 4 and look at line 1? Let me know if that helps. Or let me know when you've looked at that.
Yes. We moved to Bosque in 2005.
No, I'm sorry. Have you looked at the document?
Yes, I'm trying to find it. Could you, sorry. Sorry, is there an exhibit number you could direct me to? I'm having trouble.
Of course, Ms. Geller. You take a look at Exhibit 11 and see if that helps.
Yes.
Just let me know when you've looked at it, if it's refreshed your recollection. Don't read anything off of it.
Yes, it has.
And make sure, is that document closed now?
Yes, it is.
Is your recollection refreshed?
Yes, it is.
So how long has Chimes been where it is now?
Since 2005.
I want to focus on the stairs behind Chimes's current location. Ms. Campbell, can we display what's already in evidence as Exhibit 19? Ms. Geller, what are we looking at here?
That's the back part of our store, the loading dock.
And we've heard throughout today's trial that there used to be a railing on those steps there. Is that true?
Yes.
What happened to the railing?
It was removed.
Why did Chimes remove the railing?
We use that area as a loading dock, so it just isn't feasible with railing to load and unload merchandise.
Well, let's break that down. Why isn't it feasible for Chimes to load and unload merchandise with a railing?
Well, we get shipments in, and when we have to take them in the doors there, if there was a railing, it would be too difficult for that use.
How often is that area used for unloading deliveries?
Daily.
We've heard today that Chimes use that back area for other purposes as well, though. Is that true?
Yes.
What else was it used for?
The employees would use the trash can out there and smoke breaks.
Why do your employees take their smoke breaks out the back there?
They were instructed to take the smoke breaks in the back of the store rather than the front.
Why did you tell your employees to take their smoke breaks out the back?
To protect our customers from the smoke in the front of the store.
I want to be upfront with the jury. Ms. Gilmore or Ms. Geller, were you aware that your employees would be using those steps at the back of the store?
Yes.
So let's talk about safety. Were you here a few minutes ago when we read the deposition testimony of a federal safety inspector?
Yes.
Has Chimes, to your knowledge, ever gotten a safety citation for the stairs that we saw in Exhibit 19?
No.
To your knowledge, has Chimes ever gotten a safety citation for the loading dock?
No.
Have you ever been told that that loading dock violates any safety codes?
No.
You said earlier that Chimes moved into that space in 2005, and we heard that Miss Gilmore was injured in 2019. How many years is that between those two time periods?
14 years.
During those 14 years, if an employee was injured on the job, how would you have found out about it?
Incident report.
During those 14 years, how many incident reports have you seen where someone was hurt on those stairs?
Only one other incident report.
And to your knowledge, during those 14 years, has there been any difference or changes in terms of how that back area has been used?
No.
That injury report that you said you saw, the one not Miss Gilmore's, the earlier one, when was it?
2010 was the former incident.
And to your knowledge, when the plaintiff was injured, how many years had gone by then between that 2010 injury and when Miss Gilmore lost her footing?
9 years between us.
During those 9 years, have you seen what the back area looks like?
Yes.
During those 9 years, do you know of any significant changes made in the back area?
No.
Thank you. No further questions at this time.
Thank you. Cross-examination?
Yes, Your Honor. Good afternoon, Ms. Geller.
Good afternoon.
I want to start by talking about your connections to the defendant Chimes. You discussed on direct that this was a family business.
Yes.
And you're the owner of this business.
Yes.
So it'd be fair to say that you have a stake in the success of Chimes Department Store.
Yes.
It'd be fair to say you care about the image of this store.
Yes.
So then let's turn to why your employees were out in the back of the building in the first place. And I want to talk about some of those conditions. You knew there was no guardrail out in that back loading area, as you referred to it, right?
Yes.
And that's because you asked for that guardrail to be removed.
Yes.
So you knew your employees would be out in that back area without a guardrail.
Yes.
And you also knew that your employees sometimes worked after dark.
Yes.
So you knew that sometimes your employees would be out there after dark.
Yes.
And I want to be clear because you said you used it as a loading dock about once daily, right?
Just daily. We have shipments.
Right. But I want to be clear. You heard Miss Gilmore testify that she was out there to take out the trash and take a smoke break about 20 times a week, right?
Yes, I heard that.
So I want to turn to addressing that incident report, both of the incident reports that you spoke about on direct. I'm going to have you turn your attention to Exhibit 10 for me. Let me know when you're there.
I'm here.
And do you recognize this document?
Yes, I do.
This is the incident report from Miss Gilmore's accident from 2019, right?
Yes.
And it fairly and accurately reflects that incident report.
Yes.
Your Honor, we move Exhibit 10 into evidence.
Any objection?
No, Your Honor.
Exhibit 10 is admitted.
And I want to go ahead and have Mr. Meinkoth publish this for us so we can look at it closer. So I'm going to have him turn to the last page of this report. We've talked about the facts that have happened here, but I want to look at your employees' recommendations. So you'd agree with me that this section of the report, it says for Chimes use only to be filled out by a supervisor, right?
Yes.
So these are the things your supervisor, your employee stated about this incident, right?
Yes.
Let's go ahead and zoom in on a specific section of this then. So looking here, the question was, what in your opinion could the employee have done to prevent this accident, right?
Yes.
And the answer was, don't go outside on the loading dock without making sure the lights were on.
Yes.
But sitting here today, you know that your employees couldn't have possibly turned on the lights outside, right?
Yes.
Because there was no switch for them to do that, was there?
No.
So your own employee's statement was that they should have turned on the light, but the employees could not have done that. Ms. Gilmore could not have done that on January 23rd, 2019.
Right.
So then I want to go ahead and turn your attention, Mr. Meinkoth, we can take this one down, to the 2010 incident report. Can you turn to Exhibit 14 in your packet?
Yes. One moment, please. Okay, I'm here.
And you recognize this report as well.
Yes.
This is the incident report from 2010.
Yes.
And it fairly and accurately reflects that incident report.
Yes.
Your Honor, at this time we move Exhibit 14 into evidence.
Any objection?
Your Honor, we have no objections, but we ask for a limiting instruction that the limiting instruction that's be used only to show notice, nothing beyond that.
Your Honor, I guess I would like to know what the objection is for it being used for other purposes. This is an opposing party statement. So if they're claiming it's hearsay, it falls under 801D2D.
Your Honor, we don't have a hearsay objection. We object under Rule 403. This is substantially more prejudicial than probative in as much as jurors may decide to use the actual bases of this. For example, the employee in this particular incident having fallen as evidence that these exact conditions were still dangerous in 2019. That wouldn't be allowed because, well, we don't know that the exact conditions were the same. They can go to notice, but the conditions themselves aren't necessarily the same in 2019, 9 years later, and therefore we ask for the limiting instruction that it go only to notice.
Your Honor, if I may.
Go ahead.
First, this is incredibly probative. Your Honor, this goes to the notice issue in today's case, but it's not just required for notice. Whether or not the facts are the same goes to the weight, not the admissibility of this evidence. I intend to have Ms. Geller read the facts in this instance and agree that those were the facts. The jury can decide how similar or dissimilar they are, but certainly under 403, this is far more probative than prejudicial.
All right, the objection's overruled. This was Exhibit 10, is that correct?
14, Your Honor.
14, sorry. Exhibit 14 is admitted.
There are a lot of exhibits. It's okay. May I continue, Your Honor?
Yes, go ahead.
Mr. Meinkoff, let's publish Exhibit 14. Ms. Geller, I'm going to go ahead and have Mr. Meinkoff zoom in on the accident loss section at the bottom of this first page. Let's take a look at that. You would agree with me that this states that she went behind the building. It was dark outside when I opened the door and the light wasn't on. So I went back in and asked April where the light switch was. I read that part correctly, right?
Yes.
And then it states she told me there was no switch for that light in our store, and the only switch for that light was in the store next door. So there was nothing she could do about it. I read that sentence correctly, right, too?
Yes.
She told me just to leave the door open and use the light from inside the building so I could see where I was stepping, right?
Yes.
I did exactly that, but as I was walking down the steps, I slipped on what I think was loose concrete. I fell face first onto the ground at the bottom of the steps. There was nothing for me to grab.
Yes.
Right. Now, Mr. Meinkoff, let's go ahead and turn to the last page of this report. And again, you'd agree with me that this section, just as the section in Exhibit 10, this was the section that your employee filled out in 2010. Right?
Yes.
Let's zoom in on the last question here. According to your employee, when asked, are there any steps that should be taken by Chimes to help prevent such injuries in the future? Your employee said, make sure there is adequate lighting on the loading dock. I read that correctly, right?
Yes.
Now on direct, Mr. Ayers made a big deal out of the fact that this was 9 years ago. Mr. Meinkoff, we can take that down. But I want to be very clear, Ms. Geller. At any time in those 9 years, did you install a light switch?
No.
At any time in those 9 years, did you improve the concrete, fix it?
No.
At any time in those 9 years, did you even add a guardrail?
No.
But Ms. Geller, you'd agree with me that you were capable of installing a light switch, right?
Yes.
And I want to hone in on this light switch because you'd also agree with me that it was cheap to install light switch. It was economically feasible for you to have done so.
Yes.
No further questions, Your Honor.
Thank you. Any redirect?
Yes, Your Honor. Ms. Geller, that previous employee, the one who slipped in 2010, what did they say they slipped on?
Loose concrete.
Thank you, Your Honor. No further questions. May this witness be excused?
She can step down. I shouldn't have asked for excusing because these are both your parties. So she can step down and move closer to you at your counsel table. Okay. Any additional witnesses?
Nothing further from the defense, Your Honor.
The plaintiff is ready to proceed.
That the defense rests.
Okay. And are y'all doing rebuttals or you're ready for closing?
Yes.
Okay, very good. Then defense. Well, okay, let me ask for closing. And let me give you a time check.
Yeah, could we also have after our time check just a brief 5-minute recess to set up?
Sure. All right, so I've got for plaintiff 23 minutes, 15 seconds remaining. For defendant, 26 minutes, 16 minutes remaining. Ms. Nickel, do you want to tell me now how you want to break it up or your time for first and then rebuttal?
Yeah, if I could just reserve the remaining time, I certainly don't foresee using all 24 minutes, but if I could just reserve whatever time I have remaining after the first closing.
Do you want me to give you a countdown at any time?
Yes, hopefully I will come nowhere near a countdown, but if something happens and I reach 5 minutes left, please let me know.
I can do that. And
Thank you.
Mr. Ayers, did you want anything for a countdown?
I'll
Same
be
thing?
fine, Your Honor.
You'll
I've
be
got
fine.
6 minutes left.
There's not much more. Yeah. Okay. And you wanted a little bit of a break, Ms. Nickel, before you get started? That's fine.
Yes, please.
You do what you need to do, and then when you're ready, just you can proceed.
Thank you. I'm just going to do some quick tech checks too with my opposing counsel, or with my co-chair. Sorry, Mr. Ayers, I won't make you do my my tech checks.
Thanks.
Okay, Mr. Minkoff, if you can just do a quick, good?
I can see and hear you.
Great, thank you. Your Honor, I am ready to proceed whenever the court and Mr. Ayers are.
I am ready. Mr. Ayers, are you ready?
Yes, Your Honor, I'm here.
Thank you. Okay, you may proceed.
Thank you, Your Honor. Members of the jury, this case is about the hazards hiding in the shadows. This case is about the steps that the defendant corporation failed to take to protect their employees, specifically their employee, Miss Gilmore. It's about their failure to provide their employees with even the most rudimentary standard or safety measure. Members of the jury, Mr. Ayers told you throughout today that just because there's a fall doesn't mean there's fault. We're going to show you today why he's right. Just because there's a fall on plain old ground doesn't mean there's fault. But in this case, the defendant corporation had created a situation rife with hazards, falling apart concrete, a missing guardrail, a missing light, just to name a few. This is not a case where there's not fault. This was not a coincidence, members of the jury. These were hazards hiding in the shadows. Members of the jury, their employees, the employees of the defendant corporation, were unable to see that night. Miss Gilmore was unable to see the condition of the premises that she was forced to go out to that night and 20,000 other times before because they had failed to turn on a simple light switch. Remember what I asked you to think about during today's trial during opening. I asked you to think about this. How many injuries have to occur? What is the magic number of injuries that have to happen before the defendant corporation decides to take the simple step of installing a light switch? How many? It's not one. We know it's not two. I'll have to ask Mr. Ayers that one. So let's look at the law that you're going to be applying today. let's take a peek at the standards, the burden that we had to carry. And remember, we have to show you that we've met this burden by a preponderance of the evidence, that it was more likely than not that Miss Gilmore's fall was caused by the conditions created by the defendant, and that these three elements were met. The condition posed an unreasonable risk of harm, the defendant knew or should have known of this risk, and the defendant failed to exercise ordinary care. Now, in opening, I explained this to you as notice, risk, and choices. So let's talk about those three again. Now, I want you to pay close attention to the photos you've been given in today's trial, because Mr. Ayers and Miss Geller and Chimes Department Store, they want you to think there's nothing wrong with this scene. There's nothing wrong here. Well, we used it as a loading dock, so we couldn't possibly have a railing. Members of the jury, Miss Geller testified that they use the loading dock, I guess, daily, she said. But they themselves told you that the cashier, Miss Gilmore, the one who wasn't in charge of dealing with any of the deliveries, he used this area over 20,000 times. They sent him out here to take out the trash and take his smoke breaks over 20,000 times. Not once in those 20,000 times did they bother to put up a guardrail. Not once in those 20,000 times did they take a look at that concrete and go, oh, that should be fixed. Not once did they take the simple step of installing a light switch. Members of the jury, we weigh reasonableness by looking at the ease of the fix against the possibility of harm. So keep in mind that even if the harm today, even the possibility of harm, even if it was low, even if it was far lower than in this case, that doesn't make Chimes Department Store's actions reasonable when they had the simplest fix available, turning on a light switch. That brings us to the next element. You see, they had created this risk. They created this risk when they sent their employees out there over 20,000 times, or just Miss Gilmore out there 20,000 times, not to mention their other employees. And members of the jury, every time they sent them out there, the chance of risk, well, it went up and up and up. And by my math, it was guaranteed to happen at some point. You see, Mr. Ayers wants you to think that this is as simple as, well, it was 1 in 20,000. Those are crazy low odds. But members of the jury, that's not how risk calculations work. Every time an employee stepped foot onto that landing and down those stairs, the risk went up. So let's talk about notice. Because members of the jury, this is what they failed to mention to you was just what notice they were on. You see, you heard today there were 2 incidents. Mr. Ayers wants you to think this was 1 in 20,000. We had no idea this was risky. But members of the jury, that just can't be true. You want to know why? Because their own employees told them this was risky. Let's take a look. We have 2 incident reports today. The first is the one dealing with the incident in 2010. Make sure there is adequate lighting on the loading dock. Members of the jury, these are not my words. These are the defendant's own words. Make sure there's adequate lighting on your loading dock. And Mr. Ayers and Ms. Geller, well, they wanted to say, oh, that was 9 years ago. So that's so long ago. Members of the jury, that means the defendant corporation had 9 years to take their own advice. 9 years to have installed a simple light switch. A light switch that the defendant, Ms. Geller, said she could have installed. It could have been done. It was feasible. They just didn't do it. But let's look at the other incident report, because look at how remarkably similar these 2 are, members of the jury. When you look at the report from 2019, the employee said, oh, if employees want to avoid this, they should quit smoking and don't go outside without the light on. Oh yeah, the light that Ms. Geller told us their employees couldn't possibly have turned on because there was no switch. 2010, 2019. In both cases, the defendant themselves said, this lighting is an issue. We should fix that. But they didn't. That's notice, members of the jury. This is not 1 in 20,000. That's notice that this exact thing would happen again if they didn't follow their own advice. Make sure there's adequate lighting on the loading dock. So that brings us to risk, the second element of negligence today. Now, I want to be very clear, Because we saw that they stated today that, oh, well, OSHA didn't cite any violations. Yes, the OSHA inspector that stated himself that he doesn't think he should do too many of those. Yeah, he didn't cite us at all. Oh, you want to know what else, though, is interesting? You want to know what Chimes department store told OSHA? They said, oh, yeah, the manager told me that they always turn the light on when somebody goes out back. You and I both know that's not true. You and I both know that the defendant made the choice not to install the light switch. They also made the choice to lie to OSHA. Members of the jury, the reason OSHA didn't cite any citations was because Chimes department store wasn't honest. They didn't tell them the truth about what was happening. They knew it was not okay for their employees to be out there in the dark. So when OSHA came around, oh, yeah, we turn on that light. We make sure that's on, except for any time that they're outside. Yeah, except for those times. So let's talk about the choices they then made. Members of the jury, they failed to exercise ordinary care. And I want to remind you, this standard of reasonableness, whether they exercised reasonable care, members of the jury, it has to do with the ease of the fix and the likelihood of injury. Obviously, a business can't take every precaution out there to protect from every injury. We know that. That's just common business sense. But when the fix is as simple as installing a light switch, even if the likelihood of harm were a tenth of what it was in this case, it still would be unreasonable not to install that light switch. Why? Because it was easy and feasible. Ms. Geller told you that herself. That's what makes their actions unreasonable in this case. And I want to revisit this issue of cause because, well, Mr. Ayers, he came up here today and he told you, well, it wasn't the light. The light wasn't usually on, right? So it couldn't have been the light. It must have just been that she tripped. Here's what you need to think about, members of the jury. This is what you get to decide. Is it more likely than not that Miss Gilmore would have been injured had the defendant corporation taken the simple steps we've mentioned? You saw that diagram today. You saw that she was blocked from any light in the position she was at the time of this accident. Had they installed that light, we posed to you today this accident wouldn't have happened, but that's not it, members of the jury. Had they even looked at that concrete, fixed that concrete, this injury may not have happened. Had they put in a guardrail, this injury may not have happened. Take all those facts into consideration and ask yourself, is it more likely or not than not that the actions of the defendant had nothing to do with her injuries, had nothing to do with her fall? This was just coincidence? No. Members of the jury, this was not coincidence. These are the questions you're going to be asked on your jury instruction today. And good news, it's one simple one. Is Chimes negligent or not? Members of the jury, is it more likely than not that Chimes' failures to exercise ordinary care to avoid the risk, are they to blame today? We ask you to fill that in yes. Because the defendant, well, they allowed their hazards to be hidden by the shadows. They allowed Miss Gilmore to step into the dark that night into a risk that they created, a risk that a reasonable person would have exercised care to avoid, and a risk that they knew about, members of the jury. That's why we ask you to hold Chimes department store liable for their choices. Thank you.
Thank you, Mr. Ayers, your closing.
May I proceed?
You may.
When a person gets hurt, especially when they suffer the kind of terrible injury that the plaintiff suffered, it's natural to want to point the finger. It's natural to want to blame somebody. But the truth is, sometimes people get hurt And there's no one to blame. Sometimes people walk up a flight of stairs that they've walked up 20,000 times before. And this time, they stumble. That doesn't mean the stairs are dangerous. It doesn't mean that the stumble was caused by the stairs. It doesn't mean there's a villain lurking in the shadows. It just means someone stumbled. Just because there is a fall, it doesn't mean there's fault. That was the defense. We didn't have to prove that. We didn't have to prove anything. We had no burden of proof today. The burden of proof rests entirely with the plaintiff. They have to prove every element of their case, more likely than not. But you've seen throughout today's trial, you've seen in opposing counsel's closing argument, well, there's some elements they want to focus on. That's because there's some elements they can't prove. They weren't able to prove to you today that the area outside of Chimes was unsafe. And they weren't able to prove to you today that that area caused Miss Gilmore's injuries. So let's walk through those one at a time. The first element that the plaintiff did not prove today is that the area outside Chimes was unsafe. You heard deposition testimony today from two professionals. Let's compare their resumes. Ours works for OSHA. And she testified about OSHA regulations, Occupational Safety and Health Administration, and that's what she did, and that's what she talked about. It's who she worked for. Their expert worked for them. And lo and behold, her conclusions were exactly what the plaintiff needs you to believe. Our expert has spent 13 years inspecting workplaces. That's what she does. Their expert has never taken part in a government inspection. Our expert makes an official determination if a business has violated the law. Their expert's got an opinion. So what did our expert, the OSHA inspector, tell you? Well, she visited Chimes department store less than a year before this accident. She went inside, went out back. She saw the stairs. She saw the lights. Opposing counsel brings up the fact that she was told those lights, they were on. That's true, we acknowledge that. But the fact of the matter is, that OSHA inspector, she didn't give any citations. The other elements that the plaintiff is trying to prove, the lack of railing, the chip stairs, she saw all of those. She said, there's no violation here. There's no need to cite, there's no need to fine. This is up to code. The plaintiff today are big on descriptions. They talked about things as being hidden dangers. Talked about things as being chipped and broken and unusable and dangerous. If all we had to rely upon was what the plaintiff said in their closing statement, we'd think that people were falling off these stairs all the time. But we know that's not true. And we heard it from the plaintiff herself. We asked Miss Gilmore how often she used those stairs. She said that she was on them for 10 years, 50 weeks a year, 20 times a week, 20,000 times. Now, I know that opposing counsel just said, what's the magic number? 1 in 20,000, that's what the defense wants you to believe. That's not true. Because it's not just the plaintiff we're talking about. It's not just 1 in 20,000. Opposing counsel said themselves, Ms. Gilmore wasn't in charge of deliveries. And there were multiple employees that used the back. Over the course of 14 years, every cashier, every clerk, every manager who wanted a smoke break, every employee who took out the trash, every person who was in charge of deliveries, unloading, loading, how many of them were injured on these stairs? For those 14 years up until Miss Gilmore lost her balance. 1. And unlike Miss Gilmore's case, well, we know what happened here. He slipped on loose concrete. Something there's no evidence of in this case. I want to show you those jury instructions, the ones that opposing counsel showed you earlier. As the judge will explain, the standard, the legal standard, isn't whether the stairs were perfectly safe. That's not possible. But there's also no magic number like opposing counsel's trying to tell you. The legal standard that you're meant to look at is whether those stairs posed an unreasonable risk of harm. When a federal safety inspector says those stairs are okay, that's not an unreasonable risk of harm. When there's only one incident over 14 years, that's not an unreasonable risk of harm. When the plaintiff herself said she took those stairs up and down 20,000 times without falling, without getting hurt, without even having trouble, that's not an unreasonable risk of harm. You have to remember, Miss Gilmore, she's the only eyewitness you heard from in this case. And 20,000 times she climbed those stairs with no trouble whatsoever. You can mark no on that verdict form for question 1. And if that's how you answer that question, then you're done. But there's a second separate reason why you can't find for the plaintiff in this case. And that's because there's another element that they weren't able to prove. They weren't able to prove that those stairs caused Miss Gilmore's injuries. You see, for this case, the plaintiff couldn't just prove that Miss Gilmore was injured on those stairs. They had to prove that Miss Gilmore was injured because of those stairs. And it was the plaintiff's own testimony today that kept them from meeting their burden. It's January 23rd, 2019. The plaintiff steps outside. Are the same stairs, the same lights, the same lack of railing as the last 20,000 times. She goes down the stairs, no problem. The plaintiff said that it was pitch black. They showed that circle, they filled it in, they made it look like there was no light at all. We know that's not true, members of the jury, because I asked the plaintiff. You could see well enough to get down those stairs, right? She said yes. We know that there was light because we can exercise our common sense. They said, well, the door, it was blocking the light. That's not how light works. When the kitchen light's on, but the kitchen door's open, it's not pitch black in the living room. The plaintiff said she could see, she could get down those steps. And then she started back up. After she finished her smoke, she went up those 5 steps, 1 foot in front of the other, and she put her right foot on the platform. I made sure that this was very, very clear. She didn't miss the step. She told us that. She didn't go to put her right foot on the platform and, unable to see, stepped off the edge. She didn't just clip the platform and trip. No. Miss Gilmore herself told us she put her right foot on that platform. Did the platform crumble away beneath her? No. Was the platform unlevel, causing her to tip? She didn't tell us that. She told us something happened. Members of the jury, that's the problem with the plaintiff's case. They can't just prove that something happened and that caused Miss Gilmore's injury. And they have to prove that chimes caused Miss Gilmore's injury. Not just something. Chimes. And they weren't able to prove that today. So what caused Miss Gilmore to fall? Members of the jury, she tripped. I know that's unsatisfying. It's certainly less sensational than the plaintiff's argument. But sometimes life's not very exciting. Sometimes you walk through your living room and you accidentally bang your foot on the sofa. Doesn't mean the sofa got moved. It doesn't mean that the living room is unsafe. It just means you're human. That's what happened to the plaintiff in this case. The fact that after 20,000 times she climbed those steps and this time she slipped, it doesn't mean those stairs were suddenly dangerous. Let's go back to that verdict form. The plaintiff had the burden of proof. They had to prove that the stairs caused Miss Gilmore's injuries. And they couldn't meet that burden today because the truth is, we don't know what caused Miss Gilmore's injuries. That's why for question 1, you have to answer no. I want to be clear. We're not criticizing Miss Gilmore for tripping or for falling. We're not criticizing her for losing her balance. That doesn't make her careless. It's what makes her human. But we're asking that you not blame chimes for that. We ask you to return a verdict of not liable. Just because there's a fall doesn't mean there's fault. Thank you.
Thank you. Rebuttal?
Yes, Your Honor. Members of the jury, it's pretty hard to determine what caused you to fall when you're in the dark. There's a reason Miss Gilmore couldn't testify to exactly what caused her fall that night. And the reason is she could not see. But the reality is that you, as the jury, you're the ones determining what caused her fall that day. And to be clear, you don't have to be 100% certain. You don't have to know that it was the loose concrete or the lack of railing or the light. You just have to determine that it was more likely than not that any one of or all of those actions caused her injuries. And I want to pose a question to you. Because even if Mr. Ayers is right that it had nothing to do with the concrete and she just tripped over her own foot, if there had been a guardrail there, would she have been injured? Would she have fallen onto the ground? Or would the guardrail have caught her? You as the jury get to determine that. But I want to turn to the numbers game that Mr. Ayers is playing. I want to be very clear with you because he never answered why the defendant didn't install a simple light switch. You see, the odds of this risk happening could have been 1 in a million, and it still would be unreasonable for the defendant to not have taken a simple step that they themselves said they should take of installing a light switch, a simple step that we know they could have done at any point in time. It was feasible economically, They had control of it. It was as simple as a light switch. And members of the jury, remember the fact that OSHA didn't cite that as a violation, the fact that OSHA didn't find this unreasonably dangerous. Well, OSHA didn't know the employees would be out there without a light. In fact, they were told to the contrary. The defendant knew there needed to be a light out there. They knew that this wasn't 1 in a million. Why? Because the exact same thing had happened 9 years earlier. An employee went outside in the dark and fell. It's not 1 in a million, members of the jury. But it was as simple as a light switch. That's all it would have taken to have illuminated that area and allowed Miss Gilmore to see what was happening that night, to bring to light the hazards that the defendant corporation allowed to exist. The risk that they allowed Miss Gilmore to walk into that night, the risk that they required Miss Gilmore to step out into. And that is why we ask you to hold Chimes liable. Thank you.
Thank you. We are off the record, and for the judges, just if you want to go ahead and turn your video and mute on. And I'm assuming that y'all are all emailing your ballots. Is that right? Good. Okay. Then I'm going to step out to hand mine, and I am told that we can comment once I get the thumbs up that all the ballots have been received. So one moment, please. I will return shortly. All right, I'm back. I was told that we can comment. Hey, I'll just start off with oh, I don't have, yes, I have the lawyer. We'll wait for the judge to pop on, but just so that you know, this is a real thing. So I am a district judge north of Dallas. I have a general jurisdiction court, and I have now had 3 all remote civil jury trials by Zoom. I've got one more coming up where we're going to pick the jury by Zoom, and then the restrictions have been lifted on some of the social distancing. So we are able to, I'm bringing them into the courtroom to try the case. And then all of our criminal cases have been in person. We've just had to pick in much larger surroundings, but it's not for naught. And y'all have picked up what is the most important thing, that for all of the Zoom hearings that I do think will continue. I do think judges are absolutely going to continue to do some Zoom hearings. I don't know that we're going to continue to do jury trials this way if we're not required to. It was a nice way to get through our backlog for a while. But just being able to do the technology like you can to make it so much more interesting, I would tout that to every employer. Because not everybody can do it and not everybody's comfortable with it even now, a year into it. So awesome job. Well, I'll let who wants to give comments? We're supposed to give a critique and a good job.
I can go first, Your Honor.
Okay, sure.
First of all, I was trying to do some math on how many rounds of mock I have participated in, coached, or judged. and it's well into the triple digits, I'm sure. You guys are among one of the best rounds I've ever seen. That was just outstanding. I do not always say that. It was just very, very, very good. And it was a pleasure to watch. So one of the things that I really appreciated between the two of you, so this goes to both of you, is just the professionalism and no nonsense of we're going to fight about the stuff we have to fight about. We're not going to fight about the stupid stuff we don't. That is how the real world is. It's exactly what judges want to see. It will make you friends and referral sources out of your opposing counsel. It is exactly what you should do. And if you take nothing else away from Top Gun, which I doubt will be the case, but if you were to take nothing else away from Top Gun, do that for the rest of your career, and you'll be shocked how much success and money it will bring you. So on the flip side of that coin, Miss Nickel, toward the end, I think you were fighting a little bit. And I think for my taste, you got a little personal at Mr. Ayers. I don't talk about opposing counsel any more than I have to unless it's to compliment them in ways that don't hurt my client. Nobody likes it. So just be careful. I didn't think you crossed the line. I'm just saying, watch that. That's not the place to channel your energy is toward him. Be sure you're talking about his client, especially when it's somebody as likable as Mr. Ayers is. That's not going to work very well. And I didn't think you crossed the line. I'm saying don't let it go any further than it did. And if it were me, I would back it up just a step. The plus for you, I thought that cross was outstanding. I loved it. It was short. It was straight and to the point. Everything you asked for mattered instead of being nitpicking. So that was excellent drafting, and I just loved it. And my only other thing, the other thing you would do to channel your energy sometimes is get a little, I don't know if it's sarcastic or you'd kind of laugh. Don't do that either. That can translate and read differently than you intend it to. But it's tough. I mean, it's really tough on Zoom. It's tough in person, but I think it's even tougher on Zoom because there isn't the natural feedback of feeling a room. You're sitting here trying to figure out what it's like by video. So just watch those as you go forward, because I'm sure you will. Mr. Ayers, I thought it was great. My two nitpicks would be for opening and closing. The judge said, "Defense ready for your opening?" And your first words were, "May I proceed?" Defense ready for your closing? May I proceed? Judge Edgeworth, and I have judged before, she is a lovely person and much kinder than I am. If I were a federal judge sitting on that, it'd be like, yeah. She pitches the ball to you and says, "Defense ready for your closing." Go. Don't. I know a lot of that's muscle memory and mock trial land, and then just watch your Miss Gilmore, Miss Geller stuff. That was about 8 or 10 times of that. Maybe that's a slight overestimate, but it's easy. They're both G's. But seriously, when that's the feedback you get, you guys had a fantastic round. I loved it. Congratulations.
Excellent. All right. Mr. Zeev. Did I say it right? It's Zeev?
It's Zive, but that's
Zive. I said it right and wrong together. Okay, go ahead.
That's okay. I mean, first of all, let me echo what was just said. You may or may not know that those of us who are Baylor alums, which I think is like all of us who are judging, but they take these competitions. We were brought up taking these competitions very, very seriously at law school, all forms of them. I've judged a ton of them. I also have judged literally thousands of competitive debates in intercollegiate side. I emailed Bobby Little, who is one of the organizer of this event, who's known me for decades, and told Bobby that this was legitimately one of the harder decisions I've had to make. And that includes decisions that I've spent hours agonizing over. But I mean, just in terms of, y'all really continue to exceed my expectations on kind of an exchange basis, which is what I want from a good-natured competition like this, is to have that rhythm where you're listening to each other, you're reacting to each other, you're adjusting your arguments to account for where you think the other side may have been better. All those things, you're showing all the right signs. So all that fantastic. In terms of constructive, I thought, Jack, not to be overly familiar, but I guess I don't care. I'm going to be overly familiar, Jack. I would have cranked it back, and this is me, anyone who really knows me would know how absurd this is for me to say. I would have maybe crank it back a notch, right? I am one who loves to have fun with these formats, and you're clearly at points indulging a kind of a theatrical fun, which is I don't want to dissuade you from, because particularly in online, anything you can do to try to break through and keep yourself interesting. But you might, I think, some of your emotive content, it started to feel a little bit syrupy at points, just a touch. So just watch it on the edges, because your tendencies are so good, but I think you can just watch it. Now, Ms. Nickel, on the flip side, I thought you hit your rhythm like midway second half. If you'd come, I thought you could have cranked it up a notch like earlier in terms of like really, and I think what was said before, that I don't mean sarcasm. Sarcasm almost never translates, and I adore sarcasm, but it's just damn near impossible to make work. And in a virtual format, it doesn't work. It just does, like, unless you're dealing with an audience who knows you, just count on sarcasm not working online. So when I say crank it up a notch, I mean just like a little bit more juice, because just that coming in a little bit stronger, you can do that. And you kind of did midway through. So that's all, just a little bit of balancing, kind of tonal balancing. But overall, thoroughly enjoyed it, and a fantastic way for me to spend my Saturday afternoon. So thank you all.
Outstanding. Mr. Thomas?
Oh, hey, I thought you guys did an excellent job. Judge, you got my, I think my rights on my video turned off, but.
Oh, well, I can give you rights. Let's see. After start video.
There you go.
Okay.
Yeah, there you go. No. All right. I'm here. Yeah. I thought you both did an outstanding job. I really agree with the other judges or jurors here. I mean, that's probably, one of the most outstanding mock trial rounds I think I've ever seen. And to say that in the context of it being a Zoom mock trial is just, it's just incredible. I mean, it really did blow me away. And obviously, and the same thing too, in the context of this competition in particular, where, you have 24 hours to hit the ground running. So, it really is just mind boggling when you think about sort of all of those constraints that you guys dealt with and overcame. So, I was really blown away, and it was a, very tough decision for me. On the constructive side, and it's tough because, you have 24 hours and, it's hard to sort of polish, certain things and to have an understanding of like, how long should I talk in opening and closing? I thought they, for both competitors, I thought the openings and closings, they did go a little bit long. It's tough because, the problem is so new and there's so much stuff to talk about. And so, a lot of times we have a tendency to sort of, to put, material and information out there. And so I thought it was just a bit long for both competitors on both openings and closings. And then I think too, kind of on tone, it's tough. Again, it's a simple case, it's a trip and fall, but it's actually more trickier than that because, and this is kind of the other bit of, critique I have, for you, Ms. Nichols, but on the closing, you got very passionate, and I think your passion is great. And at one point it was almost a little bit of an anger. How dare these people have this hazard? And there's this split screen, and the split screen is, it's like it's the stairs. And so on your side, I had like this anger, but again, it's a tricky problem because it's a trip and fall. And then there's sort of these stairs that still look innocuous, and it's in the daylight still. So when you have your anger, and I thought your passion's very good, but then the picture that's kind of being shown is like, well, this actually is not that bad. And kind of that dissonance there is a little bit of a struggle. But like I said, I thought you guys did an outstanding job. I think y'all should both be immensely proud of yourselves. And like I said, these are all just very, very minor things.
Fantastic. Well, I am told that we are good to go. So ballots are in. Good luck to you both. Hope you get a good dinner and maybe a little bit of sleep tonight. And thank you so much for the attorneys that logged in and judged today and spent their Saturday afternoon with us.
Yeah, thank you all so much.
Thank you so much.
Thank you.
And thank
everyone.
you, Jack. It was a great round, as
Absolutely.
always.
It was a great round. Thanks.
Oh, you know each other. You have history. Aha.
Well, the schools at least do. So it's always
Okay.
good. You're going against,
All right.
you're going against a clean team. It's good.
There you go. Okay. Well, good luck to you both.
It doesn't surprise, I don't think, any of us that y'all were quite good. So have a good rest of your evening.
Thank you. You too.
Thanks.
Bye.